Yes.
Calling of second appeal. That
Yes. It is not listed.
not there. It is along with the concept application is also in place.
ওটা লিস্টে করে দেবো। Let me see. I'm trying. I have already started dictating. I shall deliver the job.
My lord, this matter today it was fixed as specially fixed,
Yes.
but it has not come in the list.
Huh?
At 12 p.m. today fixed. Kindly see, my lord.
Oh, so it was our problem.
Yes.
So if the file is we are not getting the file. If the file is found today, tomorrow it will be as a special fixed. Okay.
But
So
motion
generally
inclusion,
does not happen.
motion inclusion, my lord.
Yes.
2014 motion, it is not.
Yes.
Extension of interim order, item number 22 of the today's list, my lord. Let the matter appear tomorrow as to be mentioned, my lord, or under the heading extension of interim order.
22 to be mentioned.
Another is, my lord, motion, my lord, group 8, let the matter appear on Thursday, my lord. I've given the
Yes. Give this.
First.
Call the list.
Lord, I am for the petition, my lord, I am praying for withdrawal of the lead petition to file afresh on the subset cause of action. My lord, this is under the, my lord, Acquisition Requisition Act. My lord, and after 2013 Act has come, the prayers made in the lead petition, my lord, does not survive at all.
But you could have amended the.
My lord, amendment is also there, but
It will not. You will have to. So
it will make more cumbersome, my lord, amendment.
It is submitted on behalf of the
My lord,
petitioner.
I am filing the report in the form of affidavit as directed by your lordships. my lord.
Okay. তাহলে একদম প্রথম থেকে নিন, তাহলে report filed on behalf of the state respondents be taken on record. Full stop. It is next paragraph. It is submitted by Mr. Bhattacharya, learned advocate on behalf of the petitioner, that the instant writ petition relates to Act 2 of 1948. Relates to acquisition of land under Act 2 of 1948. Full stop. The said act
Repealed.
is repealed. Full stop. In order to save some portions of some parts of the said act, Land Acquisition within bracket West Bengal Amendment Act came into force, inserting
9(3)
section 9 within bracket 3 capital A and 3 capital B bracketed in Act 1 of 1894. At present, Act 1 of 1894 is repealed by right to fair compensation and আমার কিছুতেই মনে থাকে না ওই এটা comma 2030. Next paragraph. Under such circumstances, it is submitted by Mr. Bhattacharya that the petitioner wants to withdraw the instant writ petition with leave to file a fresh writ petition on the self-same cause of action. Full stop. Next paragraph. Leave is granted. Next paragraph. The instant writ petition be dismissed as withdrawn. Okay.
Let the written instruction be taken on record.
হ্যাঁ ওই ওপরে তার নিচেই করুন written instruction submitted by the petitioner be taken on record. আচ্ছা ওই তো রাইট টু ফেয়ার ওইটা বইটা দাও তো এই যে রাইট টু ফেয়ার কম্পেনসেশন অ্যান্ড
Transparency in land acquisition.
practically my memory is very short, you know. Right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013.
Same, my lord, is the SARFAESI Act.
Huh?
Same, my lord, SARFAESI.
But SARFAESI Act, practically this abbreviation has been now
Used everywhere.
used everywhere. So,
Grateful.
In short, in Act 13.
I am for the respondent number 5.
okay, এই তাহলে উনার নামটা নিয়ে নিন রেসপন্ডেন্ট নাম্বার 5 and 6. এই written instruction.
I am for the petitioner.
Yes.
Well, these writ petition relate to appointment of MR dealer at Rahana Part 2 in the district of South Purusuna under Barasa subdivision.
Point of intuit of the intuit has been taken by
What? Okay. Why?
the petitioner who is made this writ petition. Her mother is a fair price shop owner.
Barred by the statute.
Barred by the
Oh,
Barred by the statute.
That I
your mother is the fair price shop owner.
That is the admitted position, nothing.
Barred under the statute. I can show you.
Yes. Yes. Submit. What is your? But the statute clearly states that it's a bar.
No.
Achha, okay. Submit.
Well, when this writ petition was filed, I challenging the my cancellation. So subsequently, I came to know 5 respondents have been granted approval. Not yet grant the license pursuant to order passed by your lordship. Now, lordship kindly continue. I file an application on 10th August.
Page.
Kindly come to the page 21 vacancy notice. Vacancy notice serial number 3. Page 21.
Yes.
Serial number 3, Gram Rahana Part 2.
Yes.
I filed application on 10th August. Page 18.
Page 18.
This is a grief challan. Grief challans for submission of application fee. at
Yes.
50,000.
Yes.
State authority incur my application. Now, lordship kindly come to the report filed by the state authority.
Page.
Page 14.
Hmm?
Page 14 of the report filed by the state.
Page 14.
Page 14 of the report.
Oh,
Report form of affidavit filed by the state.
yes.
Serial number 9. My name is Nargis Parvin.
Yes.
Now, lordship straightway come to the page 18. Page 18, serial number 65.
Yes.
Serial number 65, right hand side. Inquiry conducted as per GO number such and such, and the report submitted in from such and such. It may be noted that the applicant is not financially solvent. 1. Registered tenancy deed not submitted during inquiry. 3. And loading unloading facility is not available due to the adequate road. adequate road. Hence, this may not be recommended. There is no other ground. What is asking my learners of both offense? Now I made an application before the sub-division controller. Now let's come to page 32 of the writ petition.
Yes.
My London advocate submitted a representation. Pursuant to that representation, sub-division controller informed me the ground for rejection my application. In connection with the above mentioned subject and reference, the undersigned would like to state on the date of inquiry 27/9/2022, it was found that the proposed place of business,
Page.
page 32 of the writ petition.
Page 32 of the writ petition is the to Monoranjan Jana advocate. Okay.
It is found that the proposed place of business of Nargis Parveen, this is my client, did not comply the geo number such and such. As there was no set in front of the proposed shop farm godown, and also loading unloading facility was not available due to the
Inadequate approach road.
and registered tenancy deed was not submitted during initiative.
Hmm.
Another important drawback was that the applicant was not found financially solvent on the date of application. Here, my lord, inquiry report as also the order communicated by the subject controller, my learned senior will take the point, since my mother has a dealer, I don't have a right to apply. That point was not taken.
That's all.
No. Now, my lord, come to the geo number 77107, as there was not complied by me.
Where do you find geo number?
Kindly
Yes.
consider the geo number. যেটা তুমি বলেছো,
Yes.
geo number মানে fair price of serial number 1,
And the size of the godown must be
along with the cover such and such.
Huh.
2, there must be a set in front of the shop
Hmm.
in account such and such.
Yes.
Can you go through this? Who 20 at least 20 people who may wait in adequate a queue in consonant with the point 23 note B 1 of from C of the WBPTS controller.
Yes.
Next one, third one, the godown must be well
Ventilated pakka structure with concrete floor.
1 and 3, I comply. With regard to 2, when I comply, now let's come to the application form.
Yes.
This is application form C.
Yes.
Now, kindly go through this serial number 2 of notification dated 21st July 2014. Serial number 2.
Serial number 2 is place of vacancy.
No, my lord. Serial number 2 of notification dated 21st July 2014.
Page.
1, my lord.
Huh?
Justice handover.
This is.
No, serial number.
This
Notification
is.
dated
Notification. Okay. Serial number 2.
2. There must be a set in front of shop to accommodate at least 20 people.
20 people who may wait in the queue.
No,
Consonant
no.
with point number.
Next.
The godown must be ventilated.
No, next. In queue, in consonant with the point 30 to
Point 23.
23, note B 1, form C. Now, let's see, can you give the just hand over the form. Point number 23. An applicant for dealership must be note that he or she shall have to abide by the following terms and condition in case he/she is offered a license.
Yes.
After I getting the license, I can complete the one.
Yes,
That is emanated in serial number 2
yes,
notification date.
yes,
Now then the subsidiary controller says I am not, I did not comply the
yes,
GO number
yes,
20.
yes, I can understand your
Now my last
submission.
next, I don't have a solvency, financial solvency. Now, so on the date of application, I find an application on 10th August. Inadvertently, I have a two bank account. One is State Bank of India, another is Punjab National Bank. On the date of application, I have a fixed deposit lying with the bank, namely Punjab National Bank. Inadvertently, I wrote in the form that fixed deposit lying with the State Bank of India. Now let's kindly consider my reply to the report.
Yes,
No, let's kindly state a come to
paragraph 9.
Yes, paragraph 9.
With regard to financial,
Yes,
with regard to financial solvency, it is submitted that due to inadvertence, fixed deposit of rupees 50,000 lying with the Punjab National Bank on the date of the application was not submitted. Yes,
That is my lord, I annex and page 10 of the supplementary affidavit.
yes,
On that one, on the date of application, I have a sufficient bank, but due to advertently, I do not mention the Punjab National Bank.
yes.
In my humble summit, this is not a ground. I can show a lordship with judgment. So,
Not, judgment is not required. You give the statute.
Lordship, the statute is statute void. Lordship, kindly see my report. There is annex the statutory provisions.
also,
There's a part by
report,
this.
there is nothing to say. I mother have a license.
License has been annexed. in the-
Yes, we kindly see my report, Lordship.
Yes, that I have seen.
Yes. Specific bar is there, my lord.
The petitioner,
Well,
the petitioner,
lordship, can
yes,
allow me to apply the reply?
what reply?
No, come to the page 12 of the report filed by the state.
Yes.
Come
Oh,
part
you
three.
have not completed?
No, my lord.
Oh, acha, acha, acha. Yes, please tell me. Page 12.
Page 12, part 3.
Huh.
Part 3, serial number 13.
Hmm.
Following person, stroke entity,
Hmm.
shall not be eligible
Hmm.
to apply for license of fair price dealer,
Hmm.
namely a person holding a license
Hmm.
of fair price dealer
Hmm.
or distributor
Hmm.
or wholesaler in his name, or a person who relative as per clause 2XA.
Hmm.
He never saw in clause 2XA.
Hmm.
Now I will come to the consider the clause 2XA.
Kindly see.
The definition of related includes family members and his mother.
Hmm.
Also, kindly come to the clause 2XA.
Yes, I have with the book with me.
Oh.
এটা নিয়ে নিন, উনাকে দিন, উনি পড়ে দেবেন।
Kindly consider the 2XA. A relative includes the family member and the following kings: son, spouse, son and daughters. My lord, I have my mother have a license. I do not live with my mother. I am live with separate place. With separate place. Now the relative include the family member and the following. I maybe come to the definition of the family member. Under
Yes.
the family member.
Yes.
But I am residing
Hmm.
in separate place with my husband.
Yes.
Therefore, my dispute circular, this clause not acted to me, or my lord, there is a twofold submission, my lord. Now, my lord, come to the approval of the private respondent. In the application, I have gave categorically stated, my mother have a license. But reason communicated by the SCP, that reason was not there.
Yes,
Since your mother have a license, you cannot entitle.
yes.
My lord, my lord, another thing, if I ineligible, then my license summarily rejected in terms of the vacancy notification. Page 11,
Yes,
page 11 of the report, serial number 11.
yes,
If I eligible, summarily rejected.
yes. I got your point. Let me.
No, my lord, another some.
What submissions do you want to make?
Approval of the private respondent given by
Why
the
do you challenge the private respondent's approval? First, you yourself, you will have to prove that you are entitled to get the license. Then you can challenge. So let me pass the order that whether you are entitled to not. The petitioner filed an application against a vacancy notification dated 11th April 2022 for grant of license of APS dealership at village Rahana within bracket part 2 within Amdanga GP in the district of North 24 Parganas. Full stop. It is submitted on behalf of the petitioner that the petitioner's application was duly accepted by the Food and Supplies Department for consideration. However, she in spite of her requisite qualification as per the vacancy notification, she was not granted license. On the contrary, private respondent was granted license in respect of APS dealership. The petitioner registers her challenge against such administrative action, administrative decision in the instant writ petition. Next paragraph. Learned advocate for the petitioner draws my attention to a letter dated 8th May 2023 addressed to the learned advocate for the petitioner by subdivisional controller, Food and Supplies Department, Barashat. In the said letter, it is stated that the application of the petitioner was rejected on following grounds, : niche number 1. There was no shed in front of the proposed shop cum godown তার নিচে number 2. Loading and unloading facility was not available due to inadequate approach of the road. Number 3. Registered tenancy deed was not submitted during inquiry. Number 4. The applicant, the petitioner was not financially solvent. Full stop. Next paragraph. With regard to non-availability of shed in front of the proposed shop cum godown, it is submitted by the learned advocate for the petitioner producing clause 23 of the vacancy notification that the petitioner is under obligation to petitioner would be under obligation to construct shed for waiting of customers, for waiting of at least 20 customers in a queue only after license is granted in favor of the petitioner. Therefore, the petitioner was under no obligation to construct shed on the date of filing the application. Full stop. Secondly, it is submitted by the learned advocate for the petitioner that the petitioner was financially solvent on the date of filing application, as she had a fixed deposit in the local branch of Punjab National Bank amounting to rupees 50,000 on the date of filing of the application, but inadvertently she failed to annex the copy of such fixed deposit with her application. Full stop. Achha. Therefore, petitioner's application are required to be dealt with by the respondent authority afresh, to decide her case. Full stop. Next paragraph. The learned advocate on behalf of the state respondent as well as the private respondent submits that the mother of the petitioner is holding a license of dealer of FPS shop and the petitioner being relative is not entitled to get fair price shop license in view of clause 20 within bracket IIIA of the WBPDS within bracket maintenance and control bracket closed order 2013. Poster. Acha. In reply, it is strongly urged by the learned advocate for the petitioner that the ground of rejection of petitioner's application was not that the mother of the petitioner is a fair price shop dealer. The grounds which are stated in the letter of the subdivisional controller has been taken care of by the petitioner, and such ground and her petition cannot be rejected on such grounds. First, at present, the petitioner, the respondents cannot take the maintainability issue, saying that the mother of the petitioner is FPS license holder. Moreover, the petitioner does not reside with her mother. Full stop. The definition of relative in clause 2 XA bracket XA does not include the daughter of an FPS dealer. Therefore, she is entitled to get license, and her application should be considered afresh by the state respondents. Full stop. Next paragraph. I have heard the learned advocates for the parties. Next paragraph. Clause 2 within bracket XA of 2013 control order defines relative, quotation in the following words, colon dash. Relative, quotation includes the family member and the following kin, দিয়ে একটা colon, এইরকম ভাবে লিখতে হবে। এখানে আছে, তাহলে আমার বইটা নিয়ে নি, বইটা তো লাগবে, এটা আমার বইটা নিয়ে, হ্যাঁ সেট আউট পেজ page 1.10 mark portion. Acha. Next paragraph. A plain reading of section, a plain reading of clause 2XA clearly shows that the 2013 control order provides an inclusive definition of the term within quotation relative. It includes family members and others being the kins of the daughter, the dealer, as stated in subclause I to VI of clause 2 within bracket XA. First, next paragraph, clause 2 within bracket M within bracket V includes a daughter within the meaning of family members. First up, it is not in dispute that the petitioner is the family member of the existing FPS dealer. Full stop. Next paragraph. It is true that the subdivisional controller, food and supplies department did not state in the grounds of rejection of application of the petitioner that her application was not to be considered due to the fact that she is a relative of she is a family member and relative of an existing FPS dealer. Next paragraph. However, when the statute VIZ, 2013 control order states that a family member and a relative is not entitled to get FPS dealership, there cannot be any estoppel against statute. Full stop. Even if the subdivisional controller or the respondent authority does not mention the ground of rejection of license of the petitioner, and the statute provides such ground, it is within the scope of judicial review by this court whether the statute, whether the application of the petitioner is application of the petitioner should be entertained under the provisions of the statute. Full stop. While examining the application of the petitioner, in consonance with the statutory provision, this court finds that the petitioner's application is not maintainable as her mother is an FPS dealer. Considering such aspect of the matter, I do not find any merit in the instant writ petition, and accordingly, the writ petition is summarily dismissed.
Grateful, my lord, grateful.
এইটা এই ভেতরে কতগুলো নোটিফিকেশন আছে আর আছে, এগুলো সবগুলো করে রাখবে। আর ওইটা 1.10 আমি তো বলে দিয়েছি। এই বইটা বোধহয় এর, আমার বইটা নিয়ে যাবেন, এইটা আমার বই, ওই বইটা দিয়ে দিন। 6
Clear আছিস? হ্যাঁ, তুই সবের টাইম কালকে
তো হবে। Termination order নেই। Termination orderটাই লাগানো। Termination order is not annexed.
There's no termination order.
Yes.
My lord, item 6 kindly give me 2 weeks time.
Why?
Or I've just been briefed yesterday. It's a chain brief.
Lord, even thereafter, whether they will be able to pursue the writ petition or not, I do not know. Because what is under challenge is a termination order, first appellate authority's order, which is an appeal from the termination. That is not annexed. I do not find it annexed, my lord. I doubt your lordship will be able to consider that at all without it being annexed.
Or just give me 2 weeks time because I've just been briefed yesterday night.
Very well, my lord. After 2 weeks, if they want to.
2 weeks?
Yeah, I am not difficult.
And adjourn for fortnight.
Grateful, grateful.
My lord,
7.
beg to appeal for the petitioner, my lord. I think the service has not been affected, my lord. Kindly give us 2 weeks adjournment, my lord.
Why this matter is coming in the list without service being affected? Out of list. Out of list.
Your Lordship, I am for the petitioner, Your Lordship. We have served upon the private respondent, but we failed to fetch the track report. Your Lordship, kindly make this case to appear on Monday.
Not this week.
Grateful, Your Lordship.
My lord, I am appearing for the respondent, my lord.
Your lordship, item number 9, Mr. Shovan Ghosh is appearing for the petitioner, lordship. Lordship, he has unable to come right now, lordship. So due to his personal difficulties, your lordship. So
during his personal, I have a lot of personal difficulty.
he asked me.
Can I say that I will not be able to come?
I apologize for that, your lordship.
No. You have come. Your apology will not be considered. You have come.
Lordship, kindly take up this matter at 2 o'clock, lordship.
2 o'clock, my lord. I have another matter fixed, my lord.
I shall take up the matter at 12 noon.
12.
Yes.
Great.
Inform your senior.
Great.
12 noon. After half an hour.
Your Lordship, I am for the petitioner. Same prayer, Your Lordship. We could not face the tracking report. Kindly let the matter
Not
appear
this
on
week.
Monday. Grateful, Your Lordship.
This matter, my lord, I am appearing for the petitioner, my lord. This is the case, my lord, compassionate appointment, my lord. On earlier occasion, my lord, petitioner come before this court, my lord. Then your lordship pass the order, my lord. Page 41, my lord.
Page 40.
41, my lord. Your
Yes.
lordship pass the order, my lord. Actually, my lord, this is very unfortunate.
Page 41, my lord.
And
Yes.
Let's
This
see,
is
is a
very-
retired
this is very unfortunate case, my lord.
Hmm.
Claim of the petitioner was rejected on the ground, my lord. Since the petitioner is a retired army personnel and pension holder. Another retired army personnel and pension holder.
That
my
I
lord-
have, that I have
Yes,
recorded in my order.
Yes, I'm grateful. my lord.
Yes.
Lordship is getting
This is very unfortunate.
13,000 Lordship per month. Lordship he is getting 13,000 of his source of income. Lordship ground Lordship were rejected. Lordship.
A pension
Lordship.
uh, cannot be stated to be a
Irregular.
Regular
regular
source of
income of a person.
Lordship.
Can a pension be income? And 13,000 rupees. Can a person maintain his family by 13,000 rupees?
Lordship, regular means of income. Lordship.
Regular means of income. And how do you
45 Lordship.
no,
page
no.
45.
How do you
The order of the SCFS.
counter this particular observation of the court that in the same locality an ex-army man, presently pension holder, namely Shukhendu Haldar, was given compassionate appointment of a fair price shop dealership with a license number such and such. It is at page 42. So a pension holder was given license.
The
And the
clause
case of-
20 Lordship.
Huh?
Clause 26. Subclause 6 Lordship. There.
In his clause, in his respect, in respect of Shukhendu Haldar, clause 26, subclause 6 did not apply. So you are applying the relevant provisions selectively. It is not a distributor. That is clause 26 is the engagement of distributor.
Clause 20, my lord.
Clause 20,
Subclause 6.
subclause 6, engagement on compassionate ground.
Compensate count. Lordship is basically he's claiming the compensate count
Hmm.
because her father was died. Lordship.
No, father died.
He is a retired person. Lordship.
Father died, he retired and he
Exactly.
died. So father does not, father was a
APS dealer.
APS dealer. Father was an ex-army man.
No. Father is not.
Oh, he is
an ex-army man.
He is
Ex-army.
ex-army man.
Applicant is ex-army man.
Applicant is an
This 47 Miller, the license of Shukhendu Haldar Miller.
He applied for the compensate ground. Lordship. After demise of his father.
This is the case completely Miller, discrimination point Miller. This is very, very unfortunate Miller. I have annexed Miller. This 47 Miller. License number and Miller coding picture. Miller.
the issue involved in the instant writ petition is whether the applicant of a fair price shop license, whether an applicant of a fair price shop license on compassionate ground may be subjected to discrimination by the state authority while the similarly situated person was granted license of fair price shop in respect of the adjacent dealership. Full stop. It is now, next paragraph, indisputably the father of the petitioner is এই শুভজিৎ আমার মোবাইলটা আছে একটু দাও না এইখানে ইন্টারনেট যদি আসে দেখে নিচ্ছি indisputably the father of the petitioner was a fair price shop dealer. After his death, the petitioner, a retired personnel of Indian Army made an application for grant of license on compassionate ground. On compassionate ground, his application was rejected on the ground that he has regular source of income from his pension, and therefore he is not entitled to get license of fair price shop. Full stop. Next paragraph. It is the next paragraph. The court can take judicial notice of the fact that in respect of army personnel, pension is granted under the scheme of the National Pension System within bracket NPS. The National Pension System is a defined contribution of pension system administered and regulated by the Pension Fund Regulatory and Development of Authority within bracket PFRDA, comma, created by the Act of the Parliament of India. First of NPS envisages a provision similar like contributory pension. The employee is required to contribute in the pension scheme. The employer is also under obligation to contribute a major share in the contributory pension fund, and on the basis of share of the employee and employer, the pension is fixed. Thus, under the NPS, pension is not an accrued income of an employee. On the other hand, it is the contribution of the employee and employer, which the employee gets after his retirement throughout the life. Next paragraph. Therefore, a pension under national pension scheme cannot be equated with regular income of an employee. In the instant case, the petitioner, being ex-army man, gets rupees 13,000 per month towards his pension because of the fact he contributed in the pension account, in his pension account. Full stop. Unless there is any contribution, comma, question of payment under NPS does not arise. Full stop. Next paragraph. Moreover, another ex-army man, comma, namely Shukhendu Haldar, was granted pension, was granted license in spite of the fact that he also gets pension. Full stop. This discrimination by the state authorities cannot be supported under the principle of intelligible differentia. Italics. Next paragraph. For the reasons aforesaid, the instant writ petition is allowed. The state respondents, especially the respondent number 3 and 4 are directed to dispose of the application of the petitioner in the light of the observation made in the instant writ petition herein above within 60 days from the date of communication of this order. Next paragraph. The parties are at liberty to act on the server copy of the order.
I am submitting not point Miller. Without Miller setting aside the rejection order Miller, they will not give it. Yeah,
আচ্ছা তা ওহো তাহলে কি
yes,
বললাম ও অলরেডি হোয়াট ইজ দ্য পেজ
page 44 Miller.
হ্যাঁ কি বললাম
45, my lord.
44 to
হ্যাঁ
46.
for the reasons stated
Without setting aside Miller,
আচ্ছা ইয়ে করুন না ওই স্টেট রেসপন্ডেন্টের আগে হ্যাঁ the order dated 8th August 2023 passed by the subdivisional controller within bracket food and supplies Bongaon, North 24 Parganas is quashed and set aside. তারপরে হচ্ছে
Grateful, my lord.
I'm grateful Miller.
ওই একদম উপরে এফিডেভিট অফ সার্ভিস বি কেপ্ট উইথ দ্য রেকর্ড।
I'm grateful Miller.
এটা কত আইটেম নাম্বার 12 গেল না
Item number 11.
11 disposed of 12
12 IFS. This is my affidavit of service. But a short prayer before going to the factual matrix. But I made a representation to the authority. But this is regarding, kindly have a look to page 26.
yes
26, 27. These two representations I have made to the district controller and I have mentioned that the advertisement which is there,
page 26 na
yes, page 26 and 27.
27 yes
These two representations I have advanced. And the advertisement I have mentioned, if your lordship kindly turns to page 15,
page
15, 15. Vacancy notice. It was in 2021, 28th of December. Number I have given my application, page 19 to 21, and the map, page 25, sketch map. Now, my grievance is that the private respondent, whose name has been made a party respondent here, she doesn't fulfill the requisite criteria which has been mentioned in the advertisement, and that is my representation too.
yes
I am eligible and she is not eligible. But at the go down and the other places, page 26, I have specifically mentioned,
yes
are not done in accordance with law and the accordance with the advertisement.
yes
But only a prayer, if your lordship kindly turns to my writ petition, page 11. But prayer A1 by directing the respondents to consider the representations
Yes.
Only this much.
Lordship, according to my understanding, Lordship, this writ petition is premature, Lordship. The inquiry process is not yet complete, Lordship. No candidate has been selected yet. Since the process is undergoing, he's under presumption that the private respondent has been already given the.
Yes.
Nobody
Nobody is selected.
no, nobody is selected.
So-
The file has been processed. That is my knowledge, the knowledge I have gathered.
Knowledge, on the basis of that knowledge that the file has been processed and you have not been selected on the basis of apprehension.
Page 26, kindly have a look.
Yes,
Kindly have a look.
yes.
Second paragraph I am reading.
Hmm.
কিন্তু দুর্ভাগ্যের বিষয় বিশ্বস্ত সূত্রে জানতে পারি যে সমস্ত
This
দিক-
বিশ্বস্ত সূত্রে জানতে পারি, is it a ground for filing writ petition?
Let I tell you,
You will have to file a writ petition against an administrative action.
True.
So
I
here
have not
বিশ্বস্ত সূত্র is
But I have
not a
not-
public law realm.
I have not read the last two lines.
Yes. You read-
হারাধন মুর্মুর নেতৃত্বে এনকোয়ারি টিম প্রভাবিত হয়ে কাকুলি হাইতের নামে নিয়োগের জন্য সুপারিশ করেছেন। These official document, these are all interdepartmental correspondence, I cannot have the access.
You cannot have the access. You
The
cannot
private
have the
respondent's name has already been forwarded. The selection, this is a selection of 2021. We are in 2022 September. 23 September.
Yes, maybe but you have not received any official
No,
communication.
I have not. That
You
I
have not also received even the computerized statement that your name was rejected.
No, that is true. But the records which I have annexed to the petition. But what I am on is, before go, if your lordship kindly do not decide. the matter-
Only satisfy me on the point. Apprehension can be basis of a writ petition.
this
You just
is-
give me one authority, I shall pass order. Please. Apprehension can be basis. No, that is the thing. Apprehension can be the basis of.
I have not.
You give me a.
But I have not only apprehended, but the last two lines say that she has been recommended.
That is also your unofficial communication.
Absolutely.
Unofficial on the basis of unofficial communication, you can maintain it.
May I reply to this? I am a candidate. I contest in a selection process. If I am not eligible and my candidature is rejected, the selected person will not give her communication to me first, and secondly, the respondents will not communicate the selection of the private respondent to
But
me.
at that stage,
I have a remedy
no,
under
you will
RTI.
You will have remedy at that stage. This court can direct the respondent authority to produce the records of the entire inquiry.
This order your lordship can ask for. Why I tell you?
At this stage.
At this stage, I am telling you why. This is a selection process of 2021.
Yes,
This is for a fair price shop.
yes,
Ultimate sufferer is the local citizen, local people.
okay.
Now, the decision has been taken. Kindly have a look through the writ petition once. I request your lordship to take paragraph 3.
Yes,
Why this advertisement was advertised? Kindly turns to paragraph 3, page 4.
yes,
Paragraph, short paragraph. The petitioner further submits that as per the decision of the government and because of the customer pressure on the current MR dealer, Messrs. A.B. Singhoroy and brothers, to provide relief, a large portion of the customers of the said dealership had been detagged and will be tagged with the dealer advertised on 28th of December 2021. This detagging has been done. This tagging has not been done. So the ultimate sufferer is the customers. This is number one. Number two is I am one of the intending candidate. I placed my candidature. For last 2 years, I'm waiting for the result. What the department has done. Now the department has come before Lordship and says this is premature. When the maturity will come? But I am putting this question to myself. This is premature writ petition.
That is with regard to prematurity, maturity, I will, then I can direct the state respondents to take the decision in the matter within a time,
Only this much.
within time bound.
Only this much, Brad.
Yes, I am passing order. I
Gotcha.
will have to go to the, I am passing order. Yes,
But,
I am passing order.
shall we wait a minute?
No, you need not wait. You will,
Namdini? I'm grateful to you.
yes, item number 13.
Jesus.
Yes,
And on the last petition, Mr. Agarwal made the submissions.
so just in order to recapitulate very briefly,
One of the petitioner's father was initially carrying on the business as a sole proprietor, and distributorship. This is a in the 2004 manner, he formed a partnership with his wife and the petitioner. That was in 2004 manner, he was tagged with only 37 dealers initially. Thereafter, since it was not viable, we made representations, they made representations. And after the distributorship of Messrs. GC, they kindly come to Annex P1. P1, page 22.
yes,
Due to demise of Prodipto Kundu, proprietor of Messrs. GC Kundu and again Kundu, one of the dealerships, 19 dealers were tagged with the distributor.
petitioner, with the petitioner.
Petitioner. And this is in 2004. Thereafter,
Yes.
this continued till 23rd July 2023.
Yes,
When my last allotment order was made, my lord, and my lord, I was allotted, my lord, finally, my lord, this was made permanent, my lord, in 2023, my lord, kindly come through, my lord, Annex P11.
page,
It starts from
page 43, allocation.
and all, there are different articles, kindly see the list, my lord, 56 dealers are tagged. So, my lord, these 56 dealers have been made permanent. There are no the 14 dealers which were tagged initially, for temporary period, that has been made permanent by virtue of this allotment. It proves that this has all the dealers have been made permanent. There are no dealers of GC Kundu on account of GC Kundu. Now, my lord, the petitioner, my lord, thereafter, my lord, after the demise of his father, my lord, in 2018, sometime in 2018, the partnership was reconstituted and it has been converted to sole proprietorship. Since then, my lord, the petitioner is running the business solely. My lord, from 2004 to 2023, for so many years, my lord, as we have continued, my lord, with and my lord, no vacancy was declared till then.
Yes,
For 19 years, no vacancy has been declared against the resultant vacancy of GC Kundu. Well, I'm once again, my lord, placing the control order, my lord, relevant provision of the control order. Kindly come to page. Engagement of distributor, my lord. Page 1.25 of the PC Act, essential company.
Yes.
And how the distributor is appointed, madam. In the event of resignation of any distributor or death or incapacitation of the existing distributor on medical ground, unless any of his or her family members is found suitable for engagement on compassionate ground, as per subclass 6, or dissolution of firm formed by a group of people, or cancellation of license issued to a distributor for any reason whatsoever. And madam, in the case of private limited company, the transfer of shareholding of that company in favor of the third party, that is other than proposed status of that company, the resulting vacancy has to be notified by the distributor of food and supplies with prior approval of the department. Now, my lord, there is a provision of engagement on compassionate ground. Okay? Only 120 days are given, madam, for engagement for application by the legal heirs of the deceased dealer.
ওটা মিউট করুন, ওটা মিউট
Paragraph-
করুন, ওটা মিউট করতে বলুন।
Paragraph 26(6). Engagement on compassionate ground, my lord, 120 days are given for application. So my lord, there is a mandatory period of 120 days. That within that period, my lord, now the dealer of the legal heir of the deceased dealer have to apply. Well, thereafter, my lord, they will take a decision. So my lord, since then, since 2004, they have not taken any decision, neither any one applied. That is not known to us. They have not taken any decision. And my lord, finally, now my lord, they have even if they say that they have tried to declare the vacancy in 2018, my lord. Since until then, my lord, they allowed us to continue for 14 years.
Yes.
So, my lord, now can a resultant vacancy, my lord, be declared after a lapse of 14 years or more than that, my lord?
Yes.
Number one. And my lord, the vacancy has been declared under 2013 control order, which is under challenge, my lord. That is also, my lord. As after promulgation of TPDS control order, my lord, your lordship knows, my lord, that 2013 control order has lost its force, my lord. But still, my lord, it is declared, my lord. It is challenged, my lord.
Yes.
So, my lord, I am placing that this vacancy, which has been declared, is not a resultant vacancy. It cannot be said to be a resultant vacancy.
Yes.
Since, my lord, there is no whisper in the vacancy notice that it is out due to death of such and such, this vacancy has been declared. And my lord, the petitioner has altered its position, my lord. For my lord, initially he was catering with 37 dealers. My lord, thereafter, my lord, 55 dealers were total 55 dealers.
56.
56 dealers with his dealership distributorship, my lord. He altered his position also, my lord. So, my lord, after so long, so many years, my lord, can this be taken away? Can again 19 dealers be taken away from his distributorship, my lord?
Yes. That's all.
That's all.
State.
Lord, we'll kindly first come to the initial tagging order. That is at page 23.
Yes.
Lord, it says that, Lord, kindly takes the language that due to demise of so and so, the tagged MR dealers of deceased Kundu are hereby relinked with you as per the table noted below on purely temporarily basis with effect from 15th March 2004 until further order for taking MR so and so serials again the weekly allotment of so and so. So, Malad, the tagging on which the petitioners today claim a right was on a completely, my lord, a temporary basis, and it was only existent until any further orders.
Yes.
Now, my lord, the petitioners had also relied on page 28. See, which says that the existing page 28 1C, the existing provision of tagging 2.5 lakh ration cards with a MR distributor and 5,000 cards with a MR dealer are to be followed, but in case of exigencies, such norms may be relaxed with proper justification. Now, my lord, petitioners are relying on that. Now, my lord, this is to be relied on by someone who had an tagging of more than 2.5 lakhs. The petitioners from the inception, at least from the time when the subject matter of this dispute starts, did not have so many cards tagged with that. What the petitioners are claiming right on was a completely temporary arrangement which was made by the state for the sake of the public distribution.
Yes.
Now, today, when the requirement is there for another vacancy to be declared, well, that exercise is being undertaken.
Yes.
Now, well, if your lordship kindly takes paragraph 26, which was relied on by learned friend,
Paragraph 26
of the West Bengal Public Distribution System Control
yes,
Order 2013.
Yes, yes. Yes.
In the event of candidate B, death or incapacitation of the existing distributor on medical ground, unless any of his or her family members is found suitable for engagement on compassionate ground as per subclause Roman 6, then after E, the resultant vacancy has to be notified by the district controller, food and supplies, with prior approval of the department. If it appears necessary for the district administration to declare a new vacancy of so and so for better function, that's a different thing. We are on Roman 1B under the 2003 control order, that within this time it has to be done what it says to. So there is a bar on us not to do it within a particular time, to give the family member of the deceased distributor an opportunity to apply before us. That cannot be taken to be a bar post that period. There is no limitation on us not to declare the vacancy. Since the temporary tagging continued, they cannot take a claim that for so and so years I have kept these ration cards, so I have become the permanently they are tagged with me.
Yes.
Tagging itself is by an order.
Yes.
When a vacancy is created or a dealer or a distributor is appointed, the tagging is given to that person. That tagging, the person may say that yes, this tagging is with me, but there also, the state retains the right to reduce or add to that.
Yes.
This is not the case here. What merely Roman 6 says is that, if your lordship kindly turns over to Roman 6.
Yes.
That in case of vacancy arising out of death or incapacitation on medical ground of any existing distributor, such vacancy shall not initially be notified. Prayer of any of the family members of the deceased incapacitated distributor having no regular means of income will be considered with preference on compassionate ground, provided such prayer along with form so and so, along with annexure so and so, and requisite fee submitted within 90 days from the date of the death of the licensee. So, the bar that shall not be notified, initially notified, is upon us for the first 90 days.
Yes.
If no application is received by us, that bar cannot apply on us.
Yes.
Now, my lord, if your lordship kindly takes their writ petition, my lord, I'll not placing all the paragraphs, but from paragraph 22 onwards, more specifically, your lordships will not find anything which says that they have altered their position in order to, my lord, facilitate this extra tagging. There were 22 says there were 17 dealers. In the change circumstances, prayer for withdrawal, so and so. Promulgation of 2015 control order, but which I'm dealing with, my lord, in my next submission. Then, my lord, the 2013 control order has lost its force. Then same 26. Then same 27. Then on clause 26 of the control order, usurpation of power, state should be fair. Statute provides a particular thing to be done in a particular way.
Yes.
Colorable exercise of power in 2032. Natural justice in 33. Again, colorable exercise in 34. 19(1)(g) in 35. Well, there is no averment how they have changed their position.
Yes.
After, my lord, our preliminary submission, my lord, before the reports were called for, when we said that there is no legitimate expectation working here, now this submission is being made that they have altered their position. But alteration of position is also a fact. It has to be pleaded somewhere that I have extended my go down or so and so. Reply te bolo. Parve to chance hobe.
Yes.
Yes. And what my learned friend will be extremely eager to show in their affidavit in reply, but paragraph 7, page 4.
Yes.
But kindly takes from 8th line.
Paragraph 7.
Paragraph 7.
Yes.
It is denied that the exercise of temporary tagging does not create any right or equity in favor of the distributorship as alleged.
Paragraph
Particularly
7 of the writ petition.
My lord?
Paragraph 7 of the writ petition.
No, paragraph 7, my lord, of the reply. It is a reply filed by, my lord, the petitioner.
Okay. Paragraph 7 of the reply.
My lord, in fact, my lord, the opposition is to be filed in court, my lord. We have missed that part.
No, affidavit in opposition by respondent number 4, it is filed.
This is 1 to 3.
1, 2, 3. Okay. Affidavit in reply. Yes. Affidavit in reply, paragraph
Page
7.
4, paragraph 7.
Yes,
8th line onwards. It is denied.
it is denied.
It is denied that the exercise of temporary tagging does not create any right or equity in favor of my distributorship, as alleged, particularly when the said temporary tag dealers were made permanent, considering the unviability of my distributorship in the interim period, and accordingly, single advice list for supply of PDS article to all 56 dealers has been issued to me by the authority, and I have altered my position accordingly. What? I asked this question to myself. How? They have engaged extra staff. They have made a bigger go down. They have made provisions for that tagging. And this entire sentence is on the premise that there is a permanent, the temporarily tagged dealers were made permanent without any order. They are not relying on any order. It is their perception that what was temporary today has become permanent only on the basis of a list of allotment, advice list, that is from pages 43 onwards of the writ petition. Page 43 to 84. But nowhere it mentions whether it's a temporary or permanent.
Yes.
But it's a case of smoke and mirrors. By producing a list where it does not mention whether it's permanent or temporary, they say a single advice list has been given to me, so everything is permanent. And because it's permanent, I've altered my position. There's no basis for either of the two submissions.
Yes.
Neither does the list on which they rely say that it's permanent, nor is there any relation with the next part of the sentence that, and I have altered my position. And furthermore, no details as to how they have altered their position.
Yes.
Since we have pointed out in the opposition, in the reports that we have filed, in the opposition that we have filed, that they have not altered their position, they deny one sentence and they say we have altered. But it's nothing more than a bare denial. No factual basis of this at all. Huh?
Yes, next.
Yes. Malad, 2011 7th, okay? 11 7th. Malad, one decision, Malad, I want to rely upon, Malad. May I give the copy, Malad, in
Yes, yes.
of
You
the
just give say what is stated in that decision, and thereafter you give the copy. I shall consider. Let me take note of it.
Malad, 2009, volume 1 SCC, page 180.
Page
180, 180. It also 11 7. But may I place, Malad?
yes.
It is well settled that the concept of legitimate expectation has no role to play where the state action is a public policy or in the public interest unless the action taken amounts to an abuse of power. The court must not usurp the discretion of the public authority, which is empowered to take the decisions under law, and the court is expected to apply an objective standard which leaves to the deciding authority the full range of choice which the legislature is presumed to have intended. Even in a case where the decision is left entirely to the discretion of the deciding authority without any such legal bounds, and if the decision is taken fairly and objectively, the court will not interfere on the ground of procedural fairness to a person whose interest based on legitimate expectation might be affected. Therefore, a legitimate expectation can at most be one of the grounds that may give rise to a judicial review, but the granting of relief is very much limited.
Yes.
Malad, only to add one sentence to that, Malad, there is no challenge to the power of issuing the vacancy notice. Malad, the power is there. So, Malad, if the power is there, Malad, that discretion ought to be left to the authority having the power to take the action. And Malad, legitimate expectation, Malad, it's a defined thing that is not properly pleaded, there is no fact, but even the point of legitimate expectation, whichever way it has come in the reply, Malad, that cannot stand in the way from a authority having the power from exercising that discretion unless it is shown that it is a complete abuse of that power.
Yes.
And Malad, lastly, the point taken is that this vacancy notice is issued under the 2013 control order.
Yes.
Now, Malad, the petitioner herself the petitioner himself is enjoying the license under the 2013 control order. The petitioner is getting the license renewed every year under the 2013 control order. The petitioner is getting the advice and running the business and is under the disciplinary control of the authority under the 2013 control order. And the petitioner is saying that the vacancy notice is issued under the 2013 control order, that is why it is non-necessary in the eye of law. But if that be so, the petitioner dealership, permanent tagging, temporary tagging, or whatever form it may take, that is itself non-necessary in the eye of law. Petitioner ought not have taken that point at all, Malad.
Yes.
But Malad, that is not the appropriate challenge in this writ petition. Though Malad, I agree, Malad, there are several petitions challenging that, where Malad, the petitioners, there are some petitioners who are not enjoying any benefit under 2013 control order.
Yes.
Well, as far as this one is concerned, the petitioners being under the 2013 control order, the license being under 13 control order, the disciplinary authority being the state will function under the 2013 control order. This action cannot be taken. This challenge cannot be taken.
Yes. If, in other words, the submission made by the petitioner is accepted, in that event, the prayer made by the petitioner cannot be granted.
Yes.
Prayer made by the petitioner cannot be granted.
In this case.
Yes. in this case.
when they are themselves submitting to the jurisdiction of the
Instead of
2013
2013 control order. Yes,
they have submitted themselves to the 2013.
yes.
Malad, though it is being stressed on, just Malad, I am not repeating the point, though it is being stressed on that for so many years it has been tagged to us. It is not it cannot be taken as a point of adverse possession. That concept does not apply. Malad, when the tagging itself is not a right, when the dealer or a distributor cannot claim that so and so should be tagged,
Yes.
then Malad, this concept that I have held this temporary tagging for so many years and suddenly for some reason it has become permanent without any order to that effect, Malad, that submission, Malad, your lordship will kindly not accept, Malad.
Yes,
Malad, tenure is not important, Malad. What is being vested is important.
yes. Yes. You are for respondent number 4.
My lord, in fact, we grew up, my lord, knowing that writ of mandamus lies when a legal right is infringed. I sincerely hope that the law has not changed, because I have not come across anything to that effect. While reading the petition, my lord, I was trying to find out what legal right has been infringed. What legal right of the petitioner has been infringed. Now, kindly take the petition once, my lord. I shall very quickly go through, my lord, the
Yes.
allegations made in the petition. Now, first one is that, my lord, the father of the petitioner, my lord, as indicated, that, my lord, he was carrying on business of the distributorship. 37 dealers were tagged. That is paragraph 5. Then, my lord, says that, my lord, 19 dealers were tagged temporarily. Kindly come to paragraph 5 once of the paragraph 5 of the writ petition.
Yes.
Page 3. Kindly come to. Upon cancellation of a distributorship license, this is not correct factually. That would appear from page 23, which is P1. Upon cancellation of a distributorship license of one Pradipto Kundu of Ranaghat, such and such, 90 dealers of the said defunct distributorship were temporarily tagged. Now, Mr. Bandyopadhyay had in fact, my lord, placed before your lordship page 23, which shows that temporary tagging. It is also their case that it was temporary tagging. That was the first one. Then they say that, my lord, there were representations. Kindly come to paragraph 6.
Yes, I am on paragraph 6.
Yes. Since the distributorship with tagging of 37 dealers was not viable. Now, my lord, the father was carrying on business as per, my lord, paragraph 2 for 6-7 decades.
Yes.
With, my lord, 37 dealers. He had no difficulty for 6-7 decades. Then, my lord, 19 further dealers were temporarily tagged. Now, then paragraph 6. Since the distributorship with tagging of 37 dealers was not viable, the partners of the firm, I pause here for a moment. Was he there? There is nothing to show that he was a partner there. The partners of the firm were assured. Again, I pause here, madam. Who assured? Now, my lord, when I say that, my lord, somebody assured me, my lord, in my respectful submission, it has to be said that, my lord, so-and-so had assured me. When was the assurance given? That is not there. Then it goes on, we're assured that the said 19 dealers since temporarily tagged will remain tagged with the firm on permanent basis to make the distributorship viable, and upon such assurance, the firm altered its position by making necessary infrastructure to serve the entire 56 dealers on permanent basis. My lord, Mr. Bandyopadhyay has pointed out, my lord, no particulars. On the contrary, my lord, my endeavor would be before your lordship to show that factually it is something else. From
Yes.
this petition itself, I will not go beyond this petition. So this is the allegation, that assurance that they would remain tagged. When such assurance was given, who gave such assurance, no particulars given. Then, my lord, kindly come to the license granted to the firm. Kindly come to, my lord, page 25. The last renewal is at page 25. Kindly come to page 25 once.
Yes.
Lordship will find, my lord, Government of West Bengal form such and such. Then license to a distributor under the West Bengal Public Distribution System Maintenance and Control Order 2013. Now their writ petition says that this control order is no more there.
Yes.
My lord, that the ground, first ground of the writ petition, I would say, is that. My lord, that cannot stand. They either, my lord, they take benefit or they don't. They, on the one hand, cannot say I am a distributor under this control order of 2013. And on the other hand, my lord, they cannot say the control order is no more there.
Yes.
Then, my lord, I shall come back to this document later, my lord. This was the license granted. Kindly see, my lord, kindly turn the page. Lordship will find it was issued on 9th of July 2021.
ঠিক আছে, পরে 5 মিনিট পরে এসো। Yes.
Then they say that in the meantime, my lord, there was a review meeting. That is, my lord, page 28, on which they are heavily relying on. Clause C, they are relying on the existing provision of tagging 2.5 lakh ration card with a MR distributor and 5,000 card with MR dealer are to be followed, but in case of exigencies, such norms may be relaxed with proper justification. But before that, kindly come to one, my lord. Proposal for engagement of MR distributor, wholesaler and MR dealer, FPS dealer to declare new vacancies. In many districts, there is marked disparity in the number of ration cards tagged with MR distributors, and also the number of ration cards tagged with MR dealers, which needs to be rectified. Now, my lord, if I rely on a document, my lord, I have to rely on the document in its entirety. I cannot say that I shall rely on one line and I will not rely on the other portion. This meeting became necessary because of this. And then they go on saying that keep in mind that in case of exigency, 2.5 lakhs is the upper limit in case of exigencies, if required. Next, my lord, kindly come to, they say that vacancy notice, my lord, kindly come to page 32. This is the notice under challenge in this writ petition. Now, 1st September 1920, sorry, 2022, 1st September 2022. Kindly see, my lord, the first paragraph. In pursuance of approval of vacancy of distributor VDA order dated, order number such and such dated 3rd June 2022. My lord, kindly take note. This notice is being issued on the basis of the approval of vacancy of distributor VDA order dated 3rd June 2022, read with number such and such dated 22nd August 22nd August 2022. Now kindly come to the prayer portion, man. Page 19 of the petition. These orders are not under challenge. The consequence of the orders is under challenge.
Yes.
My lord, without, in my respectful submission, without challenging the orders, the notice cannot be challenged.
Yes.
Because the basis of the notice is, is the orders, or are the orders. Now, this order they had challenged, or they had challenged earlier, they have challenged in this writ petition also. Now, the interesting part is, my lord, I said that on altering the position, I shall make my submissions on the basis of the writ petition. Now, kindly come back to page 28 once, 25 once.
Yes.
The license granted to the firm in 2021, page 25. I had placed this.
Yes.
This is granted to Roy Enterprises.
Yes.
Now, kindly, then, my lord, kindly come to, after the Messrs. Roy Enterprises in bold, the next is having lawful possession of the godown space at, Lordship found that one, godown 1, under Birnagar Municipality,
Word number 4.
ward number 4, such and such, Khatiyar number 6708, holding number 532, plot number 1781. Then 2, godown number 2, Birnagar Station Bazaar, etc. under Birnagar Municipality. 3, godown 3, under Birnagar Municipality, ward number 2, tag number such and such, plot number such and such, etc. 3 godowns in 2021. The notification is published in 2022. Now, kindly come to page 27.
Yes.
The license is issued to the petitioner before your lordship on 21st February 2023. Kindly see the number of godowns. Having lawful possession of godown space at godown number 1, dag number such and such, and then godown number 2. The petitioner is also aware that it is not entitled to carry on with this temporarily tagged dealers, and after 2022 publication, he has reduced his number of godowns. He has altered position, definitely.
By reduction. I'm coming just after 5 minutes. Just 5 minutes. Yes.
Now, my lord, I said that challenging the vacancy notice, my lord, at page 32, an earlier writ petition was filed. Now, in that orders were passed, kindly come to, my lord, page 36. Page 36, my lord, this was the first order passed. Kindly come to page 37. The second paragraph. Then, my lord, kindly come to any step, page 37, any step taken by the respondent in the meantime shall abide by the final results of the
This writ petition is pending.
No. Now, page 39. This interim order was not continued. Order of 8 May 2023 was not continued. Next day, my lord, rely on page 40, an order of 18th May 2023. Kindly come to the first, second, third, fourth paragraph.
Let
Kindly
the state,
first,
yes.
let the state not finally appoint anyone in respect of the vacancy notification for the FPS dealership till 14 June 2023. Now, Lordship will find, my lord, state was not represented.
Yes.
I was not a party to that writ petition. I could not have been. I was not a party to the writ petition. State was not represented. The writ petitioner obtained an order on 18th of May 2023. While doing that, my lord, with greatest of respect, what the writ petitioner did not do was, the writ petitioner did not bring to the notice of the court, my lord, an order at page 38. 27th April 2023. It's illegible, my lord. Kindly come to my affidavit in opposition once, my lord.
No, I can read it out.
Very well, my lord.
Yes, engagement of member distributor against vacancy
May I, my lord?
with reference to the above subject, the undersigned is directed to inform you that after due consideration as per control order, application for distributorship license of Najipur SKUS post Birnagar, Tahirpur, Nadia, has been approved by the Food and Supplies Department as a resultant vacancy.
It is being granted to me. That is a clearer copy or better copy is at page 68 of my affidavit in opposition. Now, kindly take up my affidavit in opposition once, my lord, because I would like to place two more documents.
Your affidavit in opposition.
Yes, my lord. Affidavit of my lord Amit Bishwash, affirmed on 12th July 2023.
Yes. Page
68 is a better copy
68.
of my lord page 38 of the petition.
68. Yes.
Then, my lord, kindly come to page 69.
Yes.
With reference to your application in response to such and such notification dated 1st September for functioning as a distributor at Ranaghat municipality, is hereby informed that you are being offered to act as distributor per terms and conditions stipulated in the order dated such and such. So before the order of 18th May was obtained, my lord, I had been appointed. These were not pointed out to the court when, my lord, the writ petitioner obtained the order of 18th May. And, my lord, from paragraph 20 and 21 of the writ petition, it would be evident that they had knowledge. They do not say that at least, my lord, the order of the document at 27th April, which they have annexed, they were not aware, my lord, contemporaneous.
Yes.
They could have made out a case that I did not know of this order at that point of time. I came to know of this order subsequently. No, that case has not been made.
Yes.
Now, my lord, if your lordship is pleased to come back to the writ petition, my lord. And I'm sorry, my lord, these three documents which I had placed before your lordship, my lord, these documents are not challenged in the writ petition.
Yes.
My appointment is not under challenge in the fresh writ petition because they had withdrawn the earlier writ petition with liberty to file a fresh one. When, my lord, this writ petition was filed, impleading me as a party, those three documents are not under challenge. Now, kindly come to, my lord, the case made out in the petition, my lord. The grounds. Kindly come to paragraph 24, my lord, page 9. My lord, 24 to 26. Lordship will find by promulgation of Targeted Public Distribution System Control Order 2015, dated such and such, the central government in exercise of power conferred by Section 3 superseded the earlier Public Distribution System Control Order 2001. Then the state government has issued West Bengal Public Distribution System Maintenance and Control Order 2013 in exercise of the power conferred by Section 3. Read with the said Public Distribution System Control Order issued by evident GSN number such and such dated 31st August 2001. Upon supersession of the Public Distribution System Control Order 2001 by the central government, the West Bengal Public Distribution System Maintenance and Control Order 2013 has lost its force. Mr. Bandyopadhyay had made his submissions. I also, my lord, indicated, my lord, that their license is under 2013 control order. So this defense, my lord, this stand, my lord, in my respectful submission cannot be or should not be allowed to be taken.
Yes.
Now, my lord, kindly come to the next point taken, my lord, kindly come to paragraph 28. This is the second point taken. Clause 26 of the State Control Order 2013 provides for engagement of distribution, and the District Controller Food and Supplies is the only authority to publish the vacancy notice in official gazette as also in local newspaper widely circulated throughout the state of West Bengal. Whereas in the instant case, the Director District Distribution, Procurement and Supply, in short Director, has issued the vacancy notification which is contrary to the statutory provisions of State Control Order 2013 and cannot be sustained in the eye of law. Oh, I understand, my yes.
Yes.
They did not proceed because, my lord, it was amended.
Yes.
The provision was amended. And, my lord, the third point taken is paragraph 32 is altering the position.
Yes.
As I made my submissions, my lord, on altering the position, that there is no particulars. On the contrary, my lord, from the licenses of 2021 and 2023, it would be evident that yes, they have altered position, reducing the
one go down was reduced.
Those are my respectful submission, my lord, on legitimate expectation, my lord. Mr. Bandyopadhyay has
Yes.
cited a decision.
Yes.
I am not, my lord, citing any decision. There are decisions, my lord, that a legal right has to be there, my lord, to claim, my lord, mandamus.
Yes.
But those are my
Anything on law point for reply?
nothing on fact.
That I have already indicated.
Yes, I know. I'm grateful for that, my lord. Normally these days it happens, my lord. Again, my lord, on fact submissions are made.
My lord, law point.
আমি কিচ্ছু law point দেখাইনি।
Practically, no law point was.
He has shown that I have not challenged
the approval granted for this vacancy notification, as I have understood, I was not clear, as I have been given donation.
My lord, may I have your
Yes.
questions? I am deeply.
My lord, my learned friend has senior learned friend has relied upon that case 32, I have not challenged the approval.
Yes.
My lord, this approval is their internal document, my lord, which does not come to our knowledge until the vacancy notification is published. My lord.
Yes.
Therefore, my lord, there was no scope for challenging this approval because their internal is a ministerial work they do, and after approval they issue the notice. So whether this notification can be issued or not, that is in paragraph 28, 29, 30. The Lordship, my lord, has dealt with 24, 25, and 26.
Yes.
The Lordship has dealt with, my lord, this type of cases where the vacancies have been declared under 2013 order, which is still, my lord, in dispute, my lord. My lord, under National Food Security Act and 2015 Targeted Public System Control Order, my lord. How I am running the business under 2013 order, because there was saving clause. Under that, the existing distributors can run, but no vacancy can be declared until there is a new control order. It's continuous submission from our side to your lordship, my lord. Your lordship.
Yes.
Now, my lord, next is that my prayers are not in form. My lord, your lordship will kindly see that challenging the publication of this notice, I have also prayed for a direction directing the response authority to restore my volume of business.
Yes.
Well, I am concerned with my volume of business. Admittedly, there is a circular that 250,000 cards is the minimum viable limit.
Yes.
And I had got 247,000. So there should not have been any deduction from those cards until it was exceeding 250,000. Now, my lord, kindly see, and it is just at the cost of it is only one page, that is 2004, that I have enjoyed this since 2004.
Yes. That is not disputed that you are enjoying it as 2000.
Lord, and that temporary cannot continue beyond 19 years. Man. And my lord, the question of assurance that no one gave the assurance, there is no document. The document at page that is advised, my lord, that is at 23rd May 2023, at page 43, itself will be speak that the entire dealers were tagged with me.
Yes.
On permanent basis. Initially, what happened, my lord, when there was temporary tagging, there were two sets of documents, one for defunct dealership and one for my existing dealership. But when these were merged, one set of document was allowed to be of continued, and that's why this advice list was given for entire all the dealers at a time. My lord, my learned friend has said that I have not said anything about altering my position. My lord, it is an admitted position. Whenever there is an additional work, I had to enter my position.
Yes.
My lord, what legal right has been infringed, my learned friend has. My lord, the authority, while deciding the minimum average ration card for viability of a shop, it gives the legal right to me because they are bound by their own decision. They cannot go beyond their own decision.
Yes.
So that is a part of the, in fact, my lord, the statute, what they are deciding. My lord, and my learned friend placed that page 40 that I did not inform. So lordship find from my statement, my lord, that I was not in knowledge of that because paragraph 16.
That you have already stated that it is a internal document of the.
My lord, that is not before the honorable court.
Yes.
Earlier repetition.
Yes.
I did not disclose that, and why I did not make him the party because
Yes.
that was not in my knowledge, and the state did not. In paragraph 16, I said so, my lord, that when the writ petition was taken for hearing, the state prayed for some more time to file report, but did not inform about the issuance of approval of this one.
Yes.
That's why, my lord, I was not. Subsequently, when the state filed the affidavit, then I came to know, then I withdrew the writ petition so that I can make him a party and I can file the fresh writ. So
It's
that-
in instant application.
my lord. That's why I made him the party. My lord, his appointment is not under challenge as my learned friend has submitted. My lord, when I have challenged the vacancy notification, all the subsequent action pursuant to that vacancy notification remains under challenge.
Yes.
These are my sons.
Okay. Thank you. Argument is heard, judgment is reserved.
Provide the copy of
Yes,
the judgment.
2009. আইটেম নাম্বার 9 যদি এটা না হয় তাহলে হবে না আইটেম নাম্বার yes.
I'm appearing for respondent oil company.
Who is for the petition?
I am appearing for the petitioner, my.
Yes, what's the matter about?
Affidavit of service. Before beginning my submissions, my lord. Before beginning my submissions, my lord, may candidate to indicate that another writ petition is pending before your lordship in this honorable court. Facts are similar, prayers are different. But if your lordship, but if your lordship wishes to, I can place that pen. But it will be for the convenience of for the justice, my lord, that both writ petitions are tagged together because the facts are same.
Here, what is the prayer?
Yes. Well, this instant writ petition has a checkered past and long list of dates. If your lordship wishes, I can take your lordship to the detailed list of dates, or can give you lordship.
What is the relief?
The issue is in 6th of December 2000, the respondents Indian Oil published a notice inviting application for LPG distribution. And accordingly, interviews were made in 2001, and my lord, a selection panel of 3 candidates were selected. Now, my lord, the petitioner is of second candidate. Now, my lord, the letter of intent was issued to the first impanel candidate. My lord, I challenge that letter of intent issued to the first impanel candidate on the ground by filing a petition in the single bench of this honorable court, citing that she is not a resident of the district in which the notice inviting application was made. Now, my lord, several litigations, my lord, things conducted, my lord, High Court, Supreme Court, all things. Ultimately, by an order dated 30th September 2011 by the Honorable Division Bench of this High Court, that letter of intent issued to the first impanel candidate was cancelled. Now, my lord, after that, the respondent Indian Oil, my lord, again filed a CAN application before this Honorable High Court, saying that they praying inter alia the modification or amendment of that order of the Honorable Division Bench, citing that that order can't be complied with because that order filed three directions. First direction was that order directed the respondent Indian Oil to consider my candidature as a second impanel candidate within 3 months. And another was another thing about the policy decision that is nullified to this. I am not pressing. Now they file a CAN application in Honorable Division Bench, citing the modification of that order, citing that this is not this order is not can be complied because that is not provided into the policy decisions of the Indian government on that date. Now that CAN application, my lord, has been disposed of by the Honorable Division Bench of this High Court and by an order dated 13th of July of 2023.
Now, the Honorable Division Bench has rejected that their prayer their prayer inter alia to republish the advertisement regarding basically negating my right of candidate of considering the candidature to issue fresh advertisement. That order, my lord, is, may I place first, is annexed. Number at page, my lord, 1 minute. Page 166. No, 166 Supreme Court order. Yes. No, this is not Supreme Court. My lord, one minute.
This is Supreme
Yes,
Court order.
1 minute. Page 177. But before that, may your lordship may turn your attention also to the prayers of the CAN application. That will make more prudent, my lord. Prayer of the CAN application in which it is being disposed of. The CAN applications. Report 134. 52 starts from 52. Prayer is at page 78, my lord. Page 78. Your lordship kindly consider page 78 first.
Yes.
Yes. May I place before your lordship the prayers? The judgment and order dated September 30, 2011, passed in the said appeal may be modified or clarified to the extent that after cancelling the distributorship of Shomila Vishwas, these are first MPAL candidate.
Yes.
The applicants and respondents may take steps in accordance with the policy and guidelines of Ministry of Petroleum and Gas.
Yes.
Now, my lord, page 79, the next prayer, my lord.
Yes.
My lord. Direction may be given and or leave may be granted to the applicant's respondent to take appropriate steps in accordance with the policy and guidelines of the Ministry of Petroleum and Natural Gas.
Yes.
Now, look, this CAN application has been disposed of, my lord, an order by this Honorable Division Bench on 13 July, and the order starts from page 177, my lord.
Yes.
Now, may I come to the operative portion for the sake of brevity. Page 184, my lord. I'm counting only the operative portion. If your lordship wants, my lord. Paragraph 19. My lord, this court takes a dim view of the conduct of the respondents. During the pendency of the application, respondents cause distributorship to be re-advertised and allotted in favor of a third party. That is, my lord, private respondent number 6.
Yes.
third 40. This was effectively nullified the right of the appellant to be considered in the distributorship. It is true that the appellant had acquiesced and permitted the creation of a third party right without the demur. This is to be considered by your lordship. Without demur, but this doesn't absolve the conduct of the respondent to circumvent the direction of the court. Now, after that, my lord, the direction for cost has been given for 10 lakhs, which that order have been complied. Now, my lord, my case is, now may I say cite their policy decision which they had this they were considering upon, relying upon.
Now the entire policy decision was adjudicated upon by the judgment delivered by Justice Sengupta sitting with Justice Bagchi.
No, they were the question is whether they had the right, to re-advertise.
Who had the right?
Respondent number 2 to 5
Yes.
had the right to re-advertise the LPG distributorship in non-compliance.
That has been given answer in paragraph 19, which you have shown. The court takes a dim view of the conduct of the respondents.
But
This conduct is subsequent to the notification of vacancy.
and that might be
It is subsequent to the vacancy notification. So court looked into that conduct. During pendency of the application, respondents caused distributorship to be re-advertised. So it is considered and allotted in favor of a third party. So not only advertisement was done, a candidate was selected and in his favor license was granted.
Yes.
This has effectively nullified the right of the appellant. The appellant's right has been nullified to be considered for distributorship. It is true the appellant had accused and permitted the creation of a third party right. So you have accused and permitted the creation of a third party right without demur. You did not take any demur. But this does not absolve the conduct of the respondents to circumstances, the direction of the court. Thereafter, the court, in its wisdom, thought that the appellant should be penalized. Appellant should be given some liberty by directing the respondents to pay certain cost. Cost was imposed. Now, when without any demur, you accused the creation of a third party right, how this again it can be challenged?
My lord, the question, if your lordship
cannot be challenged.
My lord, if your lordship comes to the paragraph just above that, paragraph 18.
Yes.
Right of consideration of candidature is also been
what also been what?
My lord, my right to consider my candidature is also been there.
Yes, under such circumstances, it becomes imperative for this court to clarify that the direction upon IOC to examine the residential status of the appellant for the purpose of appointment as a distributor is subject to the right created in favor of Hema Saha.
Yes.
The court also clarifies that there is no necessity to consider the bifurcation of the distributorship as directed in the penultimate paragraph of the judgment.
Yes.
So it is not, your right has not been, it is not stated that again, after passing of this order in the can, you can challenge or you can ask for your candidature. Because for your candidature, because of the fact that candidate number 2 was not considered, for this reason you have been compensated by way of cost. When compensation has been given, you are coming in the court of equity. Writ petition, writ is nothing but an equitable relief against an administrative action. So when a court, rightly or wrongly, the same court decided that you are entitled to be compensated by cost, now you cannot challenge.
But my lord, it was non-compliance of the order of the division bench. Within 3 months.
That has been decided. It can.
No, in the that was not the prayer only. The prayer was there. The right of.
May not be. The court can mold the prayer. In writ petition, there are several decisions, plethora of decisions that court can mold the relief. The relief was molded. Relief was molded and you are given 10 lakhs of cost.
No, I was not going to tell. I was given 5 lakhs.
So you are given 5 lakhs. But how? When your candidature, it is adjudicated in the writ petition, it was not decided, or the authority did not consider this matter. When the authority did not consider, an application was filed. In that application, the order of the division bench was sought to be cancelled. The court did not cancel the order. On the contrary, a cost was directed to be paid in the manner of compensation.
Yes.
So you have been compensated. You cannot now again claim. When you have been given a damage, you cannot again claim distributorship.
No, my lord, it is for that reason, my lord, I submitted first of all only there is another writ petition pending.
What writ petition pending?
That petition pending was I filed before the adjudication of the CAN application. There I prayed for that for consideration of my candidature. There in this writ petition I have not challenged. I have challenged the allotment of the LP distribution in favor of the private respondent number 6. May that be both be heard together. And whatever desire.
Keep the number. I will dispose it off immediately.
My lord, the prayer is set out in this writ petition, page 11, para 16 of the other writ petition. My lord wanted to see the prayer of the other.
But that should be tagged.
Okay, let it come tomorrow. I will dispose it.
My lord, may I pray item 2 and 3 may be taken up?
No. Practically, I will take up the group 1 matter.
My lord, may I humbly pray that your lordship may be pleased to permit me to make a prayer that 2 and 3 may not be taken up tomorrow for personal difficulty.
I was also having the same prayer.
So day after tomorrow?
2 and 3, my lord, may not be taken up tomorrow.
Day after tomorrow.
Lordship pleases. I am extremely grateful to my lord. I am extremely grateful. I am extremely grateful.
Today it was fixed at 12 noon. So if on day after tomorrow it be.
It will be at 12.
Grateful.
Practically, I did not get time because that matter was continuing. Motion matter, it should not continue like this, but the matter will be finally disposed of for this.
My lord, any date except tomorrow.
Day after tomorrow.
2 and 3 both.
2 and 3.
I am extremely grateful to your lordship.
This matter will be. ওইটা নিয়ে আসুন, নিয়ে এসে কালকে এটা দিয়ে দিন। আচ্ছা, এটা করে দিন, affidavit of service be taken on record. It is submitted by the learned advocate for the petitioner that between the same parties another writ petition being numbered such and such, ওটা ফাঁকা রাখুন, is pending. Let the writ petition be brought and listed along with the instant writ petition for disposal to such and such kalke for further hearing.
My lord, that's 19844 of 2022.
19844 of 2020.
I am grateful to you. কালকে তো রিভিউ দেবো এটা
বেরিয়ে গেছে।
My lord, I am appearing for the Union of India. This matter pertains to acquisition of a land. Total land was in respect of the RS plot was 1.80. Out of it,
Oh, 1.6.
1.62 was acquired, and out of that, 0.4152 was transferred in our favor.
Yes.
This was our stance. Union of India's stance is that out of 1.62, we have been transferred 0.4152. So as regards to our part of the land which we have required and now presently in position, there is no dispute.
Who is appearing?
Mr. Shakko Sen is appearing for the petitioner.
Where is Mr. Shen? And
State government is a necessary party to be
of
heard.
course, state government is a necessary party. I shall hear the state government, but if I do not find the petitioner, learned advocate for the petitioner, how do I proceed with the instant matter? This is a matter of 1998.
1998, my lord.
For how many times it is dismissed, I do not know.
May I be permitted to hand over two letters? One is of 26 September 2014, written by the government of West Bengal regarding handing over possession of the land. And another letter is written dated 10th September 2013, written by the Joint Secretary PWD Department, Government of West Bengal to the Land and Land Revenue Department, where it has been specifically stated that the land has been acquired way back in 1961 and they have already received the compensation. After that, my lord, this writ petition has been filed with a specific pleading that they are not aware of the acquisition.
No. Even if they are stopped from challenging acquisition, either acquisition must be in respect of the entire
No, it was
plot of
made
land.
in two parts as per state government. First 1.62, thereafter the rest.
So entire 1.80 was
That is the state government's version. We are not aware of that because we are concerned only about 1.62, of which 0.4152 has been transferred to us. That is in respect of RS plot number, CS plot number 227.
the instant.
May I be permitted to hand over some documents, my lord?
Yes. The instant writ petition is called on for hearing. Both the petitioners and the state of West Bengal remain unrepresented. On 24th August 2023, the date of hearing of this application of this writ petition was fixed today by a specific order. However, it is unfortunate to note that neither the petitioner nor the state respondent take step in the instant writ petition. For ends of justice, the matter is adjourned. Next paragraph. If the petitioners and the state of West Bengal are not represented, comma, necessary order will be passed. Yes, what is your stand?
It was acquired. আমাকে রিপোর্টে একটা কপি
The entire land was 1.80.
Yes. On
According to the petitioner, 1.62 was acquired.
yes.
Out of that, 4151 maybe was handed over to the Union of India. So they are concerned about 0.18 decimal of land.
Even 0.18 was acquired. When it kindly come to page 4 of my report.
Yes, এই ওটা তাহলে লিখতে হবে না দিয়ে page 4 of yes.
Then my lord, page 5 my lord, kindly come that
Page
it is
4, page 4.
para 4 para 4 onwards.
No, page 4. Page 4 is paragraph 8.
Yes, para 4 onwards.
Para 4 onwards, that means page 2.
Yes,
That
that for the purpose of construction of super highway from Calcutta to Damdam, land acquisition proceedings being number D64 of 6162 under Land Acquisition Act 1894 was initiated involving such and such acres within Moja, such and such, and thereafter, my lord, this is regarding 1.62. Then, my lord, kindly come to para 5. That it is evident from the plot.
And 1.62 acres out of 180 acres of subject land, the plot is included in the scheme area.
Yes. Then, my lord, next paragraph, it is evident from the plot
notification
index.
Under 4 of 1894 was duly published on 1261 in the Calcutta Gazette Extraordinary. It is evident from the plot index report duly signed by the conference that 162 acres, 1.62 acres out of one in CS plot number 18118 corresponding to RS plot number 127 was acquired. Yes, it is acquired 1.62 acres.
Yes. Then, my lord, kindly, my lord, initially writ petition was filed for seeking for compensation of 1.82.
1.82
Yes,
or 1.62?
1.80.
That is where you have stated?
That is in the writ petition. My lord.
Okay.
Now, my lord, then award was published on 27th March 1963. And these are the names of the awardees and award serial number, everything is mentioned, and their respective share and awarded amount.
Okay.
Then, next paragraph, the possession of the acquired land was
That
duly
is
taken.
share in respect of 1.62.
62.
62.
Yes. Then para 10 deals with the second acquisition proceedings.
That subsequently was initiated as per the proposal of the development department.
That was for 0.18.
For acquisition of 62.90 acres, even more array 0.8 was involved in the settlement for was published on 28th November. The declaration so entire 1.80 is
And my lord, the locus of the writ petitioner, now I am questioning because after section 4, section 6, my lord, they do not have any locus to challenge the acquisition proceedings.
And in fact, the writ petition pertains to the non-compliance of the acquisition proceedings in respect of the 1.80. They are fully aware about that, petitioner. May I be permitted to hand over 2 documents, my lord?
yes.
One is the transfer value regarding the 0.9444 acres. Another is the letter dated 26 September 2014 of the state government. Another is the letter dated of 10 September 2013 of the state government.
I would like to show one of
May I
few
be permitted to
judgments.
hand over?
After
No,
section 4, section 6.
entire 1.80 was acquired.
Lordship, the second acquisition,
Yes.
entire acquisition, Lordship, the second acquisition, Lordship, the award has not been disclosed. And whether the compensation in respect to the second acquisition paid or not has not been disclosed. Now, Lordship, with the first acquisition, yes. The balance, Lordship, as per
That
the
acquisition has been made, that is found from subsequent LA case number 4 of 60 of 1963-64.
Yes, Lordship, but this acquisition proceeding perhaps has lapsed because no award has been made in respect thereto. As per the new act, Lordship, the proceeding which has been
Yes, within 3 years, award is to be published. So award, yes.
Regarding the award, we are unable to find out the records. 63-64.
No, but you will have to state that whether award was paid or not, because you have stated that the award was paid in your paragraph.
That is in respect of the first acquisition.
First acquisition
And
1.62.
in respect of the second acquisition proceedings, we said section 4, section 6, possession was taken and possession was handed over to the Union of India.
Union of India.
That much.
Part of it. 4151.
Yes.
Yes. But with regard to the
Regarding the award part only, I'm lacking.
So if it is then if the award is not passed, entire notice goes, everything will lapse, and then I don't have any other alternative but to say that under 2013 Act award is to be computed and paid.
Subject to correction, perhaps after the judgment passed in Indo Development Authority.
Yes, Indo Development Authority does not dilute the position.
Indo Development Authority has said that section Indo Development Authority has stated or interpreted while considering section 24 of 2013 Act. It said either if possession is taken, no award is passed, or award is made but possession was not taken or has not been taken. In both the cases, they are only entitled to get the compensation in terms of the old act along with interest. That does not vitiate the acquisition proceedings. I'll come back with the entire Indo Development judgment.
Lordship, I shall also be citing judgments. Lordship, let him conclude thereafter. Lordship, I shall.
As I said, when she was not here, after section 4, after section 6, they do not have any right to challenge the acquisition proceedings because they do not have any locus. The original owner had the locus, but not the post-vesting purchasers.
Lordship, issue today, Lordship, when this is a writ of writ petition of 1998. The state had filed this affidavit in opposition. The stand which was taken then and the stand which is now my learned friend is taking has hell and heaven difference. What they had admitted then was that there was only one acquisition and the balance is there. Balance they have mentioned in their affidavit. Balance remains. My fight since 1998 till today is in respect to the balance which remains part of the construction which has been made by Union of India. If I am given compensation, I shall accept it because as of now, it is impractical to find out which part of that construction is mine.
Yes. এইটা একটা কাজ করুন তো এটা একটা অর্ডার করে নিন the learned advocate on behalf of the state respondents has filed a report in the form of affidavit. What judgment? Full stop. Copy of the report has been filed.
Yes.
Has been served.
Yes.
Copy of the report has been served upon the petitioner. Full stop. I have heard the learned advocate for the state respondents. it is submitted by the learned advocate for the state respondents that by VIDE LA case number LA case number 4/60 of 1963-64. The development department, within bracket now, the urban development department acquired 69.2 acres of land within Mouja Mondol Gati GNTI. And during such acquisition, 0.18 acres of the subject land was also acquired. First, the next paragraph. The learned advocate for the state respondent has also raised a preliminary objection with regard to the locus of the petitioners being the subsequent purchasers after delivery of notice under section 4 and under sections 4 and 6 of Act 1 of 1894. Full stop. Next paragraph. It is submitted on behalf of the petitioner that it is frankly submitted on behalf of the petitioner that it would be a futile attempt to find out the actual location of 0.18 decimal of land out of 180 acres of land, which were not allegedly acquired. Full stop. Moreover, in view of the stand taken by the state respondents today, the petitioners can claim compensation, and in such case the compensation is required to be fixed under the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act, 2013. Full stop. The next paragraph. The learned advocate for the state has raised vehement objection against such submission, placing reliance on the interpretation of section 24 of 2013 Act in Indore development case.
Which is reported in 2020 volume.
2020 volume, comma diye, 2020 volume 8, SCC 129. 129. Next paragraph. This court will hear the learned counsels on this point on 5th September at 2 p.m. Yes, but 2 p.m. means 2 p.m., not at 2:30. Mr.
I apologize.
Please. No, practically. Yes, হ্যাঁ ওইটা ইয়ে করে দিন, হ্যাঁ এইটার আগে লিখবেন, ওই যে ডেটটা ফিক্স করলাম তার আগে লিখবেন, the learned advocate on behalf of the Union of India has filed certain documents. Let the documents be kept with the record for consideration.
Well, let it be the first matter at 2 p.m., my lord, if your lordship kindly permits.
Today also I kept it
No, I
first.
thought well, there were some other matters, my lord.
That is the
we did a wrong.
on the next Tuesday also there will be certain other matters
Very well, my lord.
where you will be, it will be number one
Obliged.
at 2 p.m. Yes.
Lordship, item 27, I beg to appear for the petitioner. I'm led by Mr. Shomo Mojumdar, who is on legs before court room number 7. I'm praying for not today, Lordship.
I don't know, 27, item 27. Oh, okay, Lord, sir.
You are for the petitioner?
Yes, my lord, I appear for the petition.
Who is for the state?
But
Oh,
this is the
state
Union
is
of
not-
India.
Huh?
This will be the railways are the, my lord.
Railways acquired the property, so Union of India is not appearing.
কি ছিল? কে ছিল? রেলে হইবে কি? লরিয়া কি ছিল দেখো না। My lord, here the point has already been decided by this honorable court. Number this pertains to, my lord, setting up of private sidings on beside the railway tracks. But usually, my lord, we see, my lord, this goods shed, which is the public goods shed owned by the railways. But my lord, a policy was also adopted by the railways at some point of time, where, my lord, the railways have allowed setting up private sidings by certain category of persons and companies, namely cement manufacturing units, steel, iron ore, etc., who are inter alia engaged in, my lord, transportation of various materials.
In order to keep their goods absolutely in those
Yes,
sidings.
yes. Sometimes, my lord, they are also given rights to allow the third parties to use it.
To
But, my
use
lord,
it.
these are private sidings, my lord, which can be set up, my lord, under the various policies of the railways. Now, my lord, private sidings.
My lord, I am praying for short password, my lord.
What?
In this case, Mr. Kullan Chakraborty appearing for the respondent.
Who?
Kullan Chakraborty appearing for the respondent is in court number 8, my lord.
Okay.
I'm praying for short password.
So you please take note of the submission made by the learned advocate for the petitioner, and thereafter tell Mr. Chakraborty to give answer to these issues raised by the learned senior counsel on behalf of the petitioner. For this reason, I cannot.
Now, my lord, private sidings, my lord, can be of three types. One type is where, my lord, the entire private siding is built on private lands. Another can be, second category is where, my lord, the private siding may be on railway land. Where there is a third category where, my lord, private sidings can come up in both private land as well as railway land. Say 75% is private land, 25% is railway land. But ours is a case, my lord, which fall under the third category.
Okay.
Now, my lord, for this purpose, my lord, the railways had licensed in favor of the petitioner 9.23 acres of railway land.
Okay.
My lord, the railways are entitled to, my lord, license fees for letting out this land to private entities.
Yes.
Now, my lord, for the purpose of calculating, my lord,
What is that? That is rent.
yes, license fees they call it.
License fee.
Yes.
Now, my lord, for the purpose of calculating this license fees, but again, my lord, the railways, they issue circulars from time to time, which are called, I think, freight marketing circular.
Yes.
But the dispute before my lord today is, my lord, which of the circulars would apply?
Which of the circular
will apply?
apply?
My lord, there are two circulars, my lord, which, my lord, the parties are fighting against each other as regards the applicability.
Yes.
My lord, according to us, the 2005 circular would apply.
Yes.
My lord, according to the railways, after the 2008 circular has come to the to the effect, 2008 circular would apply.
Yes.
Now, my lord, this is the point of dispute, my lord, which calls for your lordship's consideration and adjudication. That whether the 2005 circular would be applicable or 2008 circular would be applicable in the matter of determination of the license fees. Now, my lord, in support of our submission that the 2005 circular would apply, my lord, our case is that the relevant period when, my lord, the land was licensed to us, the circular then existing would be applicable. Where the other aspect of the matter is,
Yes.
but the other aspect is that, my lord, in the matter of setting up a private siding also, my lord, whether it is in each of the three categories, whatever it is, my lord, the railways keep complete control in the matter of granting approval till the commissioning of the siding. Or in other words, my lord, at various phases, my lord, railways grant approval to us and we have to construct or proceed according to the approvals granted by the railways from time to time. But this is for the setting up of the private siding.
Yes.
Now, my lord, the first approval, my lord, it is called in principle approval.
Yes.
Now, my lord, if your lordship may kindly take, my lord, page 80 of the writ petition.
Yes. Annexure P3.
Annexure P3. But your lordship find, my lord, this is dated 3rd of March 2006. My lord, this is a letter which is issued by the Southeastern Railways to, not to me, to Messrs. KVR Rail Infra Consultancy Services Private Limited.
Yes.
Well, in the subject, your lordship would find proposed private railway siding of Messrs. Rungta Mines. Rungta Mines is the petitioner at so and so place. The preliminary proposal for developing private railway siding on the above mentioned section submitted with a letter under reference is approved in principle subject to so and so stipulation. But your lordship need not go into these stipulations that would not fall for consideration before this honorable court.
So this is the preliminary proposal.
Yes, this is the first in principle approval, my lord, that is issued in favor of my client.
Approved in principle.
Yes. আচ্ছা সাপ্লিমেন্টারি এফিডেভিট ফর্ম করো ফাইল করো আছে Milord, this 9.23 acres of land, Milord, this was licensed out in favor of my client, Milord, on 1st of May 2007.
1st of May 2007.
2007.
Where,
Milord, I would require to file a supplementary affidavit to bring this on record. Milord, we have served a copy on my learned friend. Milord,
so land was handed over
on 1st of May 2007. 9.43 acres of land.
yes.
But when the land was handed over to me, Milord, a circular dated 10th of February 2005 was operating in the field. Please have a look to this at page 183.
Yes.
Milord, please have a look to Milord, page 183 now.
Yes.
Milord, this is the circular which was operating in the field, Milord, when I was given this land on license.
6%.
6%. But I fall under category E, which says land used to lay private siding. Milord, previously it was annual license fee. Milord, please take the third column head. Annual license fee as a percentage of the land value from 1,495 to 31/3/2004 in terms of board's letter dated 29/8/1995. Initially, it was 6%. Then annual fee, annual license fee as a percentage of land value from 1/4/2004 onwards in terms of board's letter dated 24/3/2004 is 6%. So in our case, where it was not altered, it was 6%. Now, Milord, for this land licensing fees, I mean, for granting this license, Milord, they are entitled to raise, Milord, license fee bills, Milord, which they had started raising. The first bill, Milord, in this regard, your Lordship would find at page 99 of my writ petition. But here your Lordship find at page 99, this is the first bill, Milord, which was raised in favor of my client. The competent authority has approved the proposals for licensing of railway land for construction of your private siding as per details given below. Area of land is 9.23, security deposit 27 lakhs, land license fee, and I don't know what is CC.
Completion certificate or something like that. CC.
Yes, I was thinking of that.
We generally use
Yes,
CC as completion certificate.
Yes, in the municipal
laws. Yes, laws.
Yes. So
After construction, CC is required.
Yes.
Otherwise, you will not get water connection.
Yes. Water, sewage.
Water, everything.
So land licensing fees is 25 lakhs, 38,000 and not total, etc.
Yes.
So you are requested to arrange to deposit the full amount.
Yes.
Now, this is the first bill. Now, please take, my lord, the second bill. Well, this bill at page 99 is not that elaborate. Now please take note the second one at page 160.
Yes.
160, your lordship finds where this is elaborate with all the details. Where please take me lot serial number 5. Land rent rupees 27 lakhs 69,000, then within brackets 6% of the market value as per Railway Board circular dated 10th of February 2005. Very specific, very clear.
Yes.
But this does not affect my right.
Yes.
Well, now comes another circular which was issued on 28th of August 2008, which is called the FM circular number 12 of 2008, which my lord will find at page 151.
Yes.
This is the policy guidelines for permitting construction of private sidings for loading of iron ore. Where background, etc., has been stated, Millard. Instead of troubling your lordship with everything, Millard, please come to Millard clause number 6 at page 155.
Yes.
The license fee for railway land utilized for providing connectivity of the siding on private land or laying the siding on railway land shall be 6 times the normal license fee for the licensing of land for the siding as per the extent rules. This is Millard 6.1. Now please turn the page 6.2. Similarly, the commercial plots for stacking of iron ore shall be licensed temporarily at 6 times the normal license fee. That doesn't trouble me. Then please take 6.3. As the private sidings on railway land and the stacking area shall be used by more than one party, suitable mechanism for apportioning of the initial development cost, license fee, etc. of such sidings amongst the users should be developed by the zonal railways. Railway land would be licensed for development of private iron ore sidings as per the procedure for a period not more than 10 years. After 10 years, the siding will be taken over by the railways and converted into multiple user, etc. Then please take the paragraph 7.1.
Yes.
Application should be considered in a peaceful
Should not be considered.
I'm sorry, should not be considered in piecemeal manner or on first come, first served basis. The exercise should be conducted every 6 months by inviting applications through an open advertisement, through newspapers, and also giving wide publicity, including through Railways official website. Now, please turn the page. Paragraph 7.2, it says that for the present, all applications which have been received shall be returned and fresh applications will be called within a specified date. Thereafter, Millard, 7.4. Well, because my permission was given Millard in 2000, already granted, so I come under this. 7.4, as far as the cases where permission has already been given, a case-to-case review will be done by the general manager, and if the siding permissions are as per these guidelines, then the same shall be allowed to continue. Otherwise, they shall also be asked to apply afresh as per advertisements. But these are, Millard, the relevant provisions which I need to draw your lordship's attention to. The first of which is 6.1. But instead of 6%, which was, Millard, in 2005, now it becomes 6 times of the normal license fee.
Yes. Yes.
Now, my lord, comes the next error, my lord, after the 2008 circular. My lord, the first bill, my lord, in terms of this 2008 circular, my lord, your lordship would find, my lord, at page 166. My lord, below the heading, kindly see, my lord, it is written bill for annual land charges for the period from 1/4/2008 to 31/3/2009 and 1/4/2009 to 1/4/2010 for private siding at such and such. Room termines amount to be paid for the period 2008-9. It shoots up to 98,76,126. Then the amount to be paid for the period 2009-10, it goes to 1 crore 90 lakhs 21,000 and odd. The total comes to 2 crore 88 lakhs. Now, my lord, I raise an objection to this, and my lord, but I pay. My lord, that your lordship would, my lord, find from the next page, that is 167. Where my client writes to the senior DFM, kindly refer to your letter number so and so dated 4/11/2009 on the above aforesaid subject matter. We find that we have been called upon to make a payment of rupees 2.88 so and so, along with annual land rent charges for the period so and so in respect of the above siding. However, we have not received the calculation sheet said to have been enclosed with the letter under reference. We therefore request you to kindly send us the same for our perusal. However, in the meantime, we are enclosing a demand draft of such and such amount in favor of so and so, being the deposit of annual license land rent charges for the period such and such, thanking you, etc. But unfortunately, my lord, there is no reply to this. Then, my lord, comes another bill, which your lordship would find, my lord, from page 171. Now, the bill for the next financial year comes, which is 1/4/2010 to 31/3/2011. Serial number 6 and 7 is important.
Yes.
6 is land rent license fee is 33 lakhs 92,000 and so within bracket 6% of the market value. That is as per 2005. Serial number 7 is revised license fee 6 multiplied by 33 lakhs. So this is under the 2008 circular. 2005 says 6% of the market value, and
2008 says
6 times.
6 times of 6%.
6%.
That means practically 36%.
This is the dispute before my lord. But one more fact that I need to tell your lordship is, now this 2008 circular has been recalled or withdrawn in 2014. This, my lord, will find, my lord, in the supplementary affidavit, which I have, I'm seeking leave of your lordship to permit me to file, my lord, because, my lord, this was after my writ petition. My writ petition is of 2010.
Yes.
My lord, this has been withdrawn in 2014.
Okay. So,
We have served. Kindly give me leave to, my lord, bring this on record.
So it was recalled, and what is the position now?
Well, according to me, my lord, we go back to 2005.
No, what has been written in the
Yes.
recalling order?
My lord, well, this is again another freight marketing circular at page 87 of my supplementary affidavit.
Or policy guidelines related to freight marketing circular.
Circular number 12 of 2008. This is the one with which, my lord, I was affected.
Yes.
1.0 says policy for construction of private siding for loading of iron ore was issued with a freight marketing circular number 12 of 2008 under board letter number etc. dated 28/8/2008. Attention is also invited to board circular number so and so dated 29/9/2014, that is freight marketing circular number 18 of 2014. It has been decided that the policy guidelines contained in the freight marketing circular number 12 of 2008 regarding construction of private siding for loading of iron ore is hereby withdrawn. There will not be separate policy for iron ore sidings. All sidings shall come under the purview of liberalization of siding rule circular. In this connection, for resolving the proposals which are at different stage, the complete guidelines have been circulated with a number etc. dated 29/9/14, that is freight marketing circular number 18 of 2014. This issues with the concurrence of the finance department. Therefore, my lord, we land up to that liberalization of siding rules. My lord, para 2, the last sentence.
Yes. This circular dated 29 September 2014.
Yes, ma'am.
It is annexed. Is it annexed?
My lord, possibly not. Possibly not.
So this, what liberalization they have announced, or they incorporated, that is to be looked into first.
My lord, this is. I don't think that is there. No. Yes. Look, freight marketing circular number 18 is annexed to this at page 84.
Now, did they give you any concession?
No, for me, my lord, I go back to the liberalized policy. That
has been stated in
the second paragraph or at page 87. 2.0, please take, my lord, the last sentence.
There will not be a separate policy for iron ore sidings.
All sidings shall come under the purview of the liberalization of siding rules circular.
Yes, what is liberalization of siding rules circular?
This, in my respectful submission, is page 183 of the writ petition.
That means the
2005 circular.
2005 circular.
Yes.
No, sir. Kindly come to page 84.
Yes, ma'am. I'm on 84.
Page 84 of the supplementary affidavit.
Yes, ma'am.
2.1.
Yes.
Sidings that were constructed or given approval before the issue of freight marketing circular number 12 of 2008. In this you come.
Yes.
You are coming, will come under the purview of siding policy prevalent at that time. That means at that time, absolutely 2005.
Yes.
Whether the siding was constructed under liberalization of siding rules on private land or on the later of 1997, absolutely you are coming.
I am coming under 2005.
Yes. Petitioner is coming under 2005 circular.
Yes.
Yes.
Therefore, my lord, we go back to the 2005 circular, which is, my lord, page 183 of my writ petition. To give your lordship, the entire 2005 circular, please take page 178 of my writ petition.
Yes, that you have shown.
I had shown 183 only.
183.
But page 178 is the complete circular.
Okay.
How things are to be done.
Yes.
Well, please take note, this is the complete guideline. Kindly see the subject. Policy on licensing of railway land for commercial plots, etc. Market circular, master circular. Please take 2.1.
Yes, leasing of land.
Or if I may read the previous paragraph also, this is in the nature of a consolidating circular. But please take the third line of the unnumbered paragraph. With a view to bring all such policy instructions under one umbrella, it has been decided to issue a master circular combining all the instructions issued so far on the subject. Henceforth, railway should quote only the present letter for any further reference.
So it is a master circular.
Master circular consolidating whatever all the circulars that were prevailing at that point of time. Then 2.1, leasing of land is not permitted except in cases where it is specifically approved by the railway board. Lands for the purpose of commercial use should be given on licensing basis only. In this case, so and so. But the rest, I don't think necessary. Now, please take page 179. Clause number 3, rates.
Land used to lay private
siding 6%. Then 4 is formation of standing committee. I need not trouble your lordship with those. Now please take the fixation of land value at clause 5 at page 180. But how the land is to be valued, a market value would however be required to be taken to serve as a base value for working out the rental fee. This shall be fixed on the basis of the land value on the surrounding areas as on 1185, as determined by the revenue authorities. That is local tehsildars, in our case, revenue officers. Land value of the surrounding areas as determined by the revenue authorities and or from the following: evaluation of the town planning, actuals as per PWD transactions, actual transactions as per documents in the office of sub-registrar, value of land assessed by professional evaluators of the state and central governments. The land value as worked out shall be increased every year on the 1st April starting from 1/4/1986 at the rate of 10% over the previous year's land value to arrive at the land value for the following year, based on which the annual license fee shall be fixed. From 1/4/2004 onwards, the land value shall be increased at the rate of 7% per year over the previous year's value. Then rest is not required. Then 7.1 speaks of revision. My lord need not be troubled with those. The rest is not required. And then finally 183. Now this is the entire composite consolidated scheme insofar as letting out, fixation of market value, and then fixation of percentage as a license fee, and then revision of the license fees.
Yes.
So therefore, my lord, there are 3 circulars, my lord, which is required for your lordship's consideration. The first one is 2005,
then 2008,
and finally 2014. Now, my lord, for the 2008 circular, I have got some additional submissions to make. 2005 circular, my lord, the details, my lord, your lordship has found, is based primarily on how to fix the market value and then fix the license fee, revision, etc. 2008 circular is not a circular only on the aspect of land licensing. I'll tell you, lordship, why. Please come back to page 151.
151.
Yeah, 151, that 2008 circular.
Yes.
But I skip over Millard the background portion. Please take Millard paragraph 2. Just to give you a lot of examples that Millard, this is not confined to only land licensing. Take 2.1.
Yes.
The zonal railway should first work out as to how many additional connections are feasible from a station along with the space for commercial plots for stacking of iron ore along the length of the loading line. Then the zonal railway should thereafter assess the quantum of traffic that can be carried over the particular section given the present line capacity, etc. Having fixed the operational feasibility as above, therefore, Millard 2.1 and 2.2 is operational feasibility, nothing to do with land licensing. Having fixed the operational feasibility as above, all applications should be prioritized in the following categories of priority. So this is again, Millard, prioritization scheme as well. Millard, the priority is given, Millard. First is the integrated steel plants having so and so capacity. Then priority B goes to producers of steel, pig iron, etc. Then kindly turning the page, the third priority is for the miners. And next is stevedores, traders, etc. Then comes Millard, para 2.4, Millard, private sidings on private land. Then 2.5 is private siding on railway land. Then please take Millard 3.0 at page 154.
Yes.
This is registration fee. A non-registration fee should be levied along with the application for construction of each new siding as under 10 crore for siding on railway land, 5 crore for siding on private land. In case it is not feasible to grant permission for construction of the siding as per the guidelines, 99% of the registration fee shall be refunded. But these are all at the beginning stage. I apply with a registration fee. If I'm found not eligible or for some reason it can't be given, I get back my license fee. Then what document should I file? 4.0. So and so documents are required to be filed. Then turning the next page, 5.0 is layout plan, operation, etc.
It is practically grant of
Right.
It is practically grant of new license
Right.
upon
new applications.
Upon new applications and upon fulfillment of certain
criteria. And what happens to the permissions which has already been granted, like my client's case? This I've shown Millard at page 156.
That is 6.1 and 7.4.
7.4. More particularly 7.4.
Yes, 7.4 is 6.1. It starts, but 7.4 is the practical.
Actually, Millard, the assessment on case-to-case
Yes,
basis.
yes.
Therefore, Millard, this is a circular of 2008, Millard, which is not only confined to land licensing fees, it is an all-pervasive circular for the purpose of prioritizing, applying, selecting, rejecting, and with that, Millard, land licensing. Therefore, for all practical purposes, Millard, the 2008 circular was issued in respect of new applicants, or the application which would come before the railways for the future.
Yes. Any other point?
Yes. Page bolo, page bolo. না ঠিক আছে ঠিক আছে ঠিক আছে পেজটা বলো কপি দাও আমার কপিটা দাও না এটা দাগ নেই but this issue had fallen for consideration before this court in an earlier petition.
Okay.
Well, one more fact made I need to tell you, Lordship. So far as I am concerned, Milord, now, Milord, I have transferred this private signing of mine to JSW, well, which also, Milord, I have disclosed. Now, today, Milord, I am no more the owner of this private siding. It has been transferred to another entity, Milord, under an agreement where, Milord, the Southeastern Railway is a party.
Okay.
Therefore, Milord, my liability, whatever it is confined to the date till which, Milord, I was owning it.
Yes.
Therefore,
In the
Milord,
date you transfer.
yes. Therefore, Milord, whatever is my liability, whether under the 2005 scheme or under
Before
the
transfer.
before transfer, this I need to, Milord, tell your lordship. The copy the. But this issue has been no.
My copy has not been prepared.
No, your lordship's copy has been prepared. Milord, it's only to check up that the underlined one does not go to the court. But this is an unreported one. It's a copy and zero. But this is a judgment of Justice Indira Banerjee.
Here also Rungta Mines Limited is the petition.
Yes, yes. In respect of another siding. But the first few pages made are on, Milord, the facts. Milord, please take Milord paragraph page 24. Or, Milord, if I may take your lordship to page 23 first.
Okay.
But the contentions, Milord, Mr. Shoktinath Mukherjee at the third line, Mr. Shoktinath Mukherjee, senior advocate appearing on behalf of the petitioner, submitted that Freight Marketing Circular number 12 of 2008 lays down the policy guidelines regarding development of sidings by private investment on railway land and private land. The purpose of the Freight Marketing Circular is to prioritize the applicants for operational feasibility. Mr. Mukherjee further submitted that the Freight Marketing Circular lays down the procedure for dealing with applications for setting up of private sidings. The circular is applicable at the application stage. It is not applicable in the case of a project on the verge of completion on the basis of permissions and approvals granted approvals at different stages. Mr. Mukherjee argued that the Freight Marketing Circular is an administrative circular, cannot be given retrospective effect, taking away a right that has acted in favor of the petition.
In favor.
It should be accrued. I stand corrected. Mr. Mukherjee argued that paragraph 7.4 of the Freight Marketing Circular number 12 of 2008 is applicable in cases where only permissions have been granted but nothing further done. It does not apply in cases where after initial permission various approvals have been given and the petitioner has acted on the basis of such approvals and where the private siding is on the verge of commissioning. Then, Milord, judgments, Milord, have been relied. Kindly skip over the judgments for the time being. Then please take, Milord, the submissions made by Mr. Ashok Chakraborty, Milord, at page 25.
Yes.
Last paragraph over there. Or, Milord, the date is relevant for me. Please take the second last paragraph.
Yes.
Mr. Ashok Chakraborty, appearing with Mr. D.K. Singh on behalf of the respondent, submitted that the railways had, by its letter of 3rd March 2006, granted in principle approval to the proposal of the petitioner to set up a private siding at Jaroli. Milord, my in principle approval is 3rd of, oh, this is also 3rd of March, same day. Yes. Mr. Chakraborty argued that one of the conditions in the said letter of 3rd March was that the railway transport clearance would be required to be obtained from the director of etc. It is also a specific condition that the petitioner would submit annual report to the respondents. The petitioner has failed to submit annual reports as specified in etc. Such and such. Then, Milord, on the circular aspect, Yes. Yes. We have page 31, the second paragraph. Mr. Chakraborty strenuously argued that the proposed agreement has not been finalized, and as such, there was no question of interference with the action of the railways when there was no concluded contract. This sentence was not required. Please take the next sentence. Mr. Chakraborty tried to impress on this court that Freight Marketing Circular number 12 of 2008 was in public interest, as integrated steel plants would generate employment in steel industry as well as associated industries. In addition, the railway would benefit by carrying more freight and generating more revenue. Mr. Chakraborty argued that private interest should yield to private interest. Private interest should yield to public interest. The petitioner's claim should therefore not be entertained by this court. Then, my lord, the Freight Marketing Circular is prospective. That is, my lord, 7.4 again is quoted. Then, my lord, the view of the court from page 32, the last paragraph.
Page 32 to last paragraph. This court is
Yes,
of the-
this court is of the view that para 7.4 is applicable in cases where permissions have been granted and requests for approval as required are awaiting consideration. As argued by Mr. Mukherjee appearing on behalf of the petitioner, para 7.4 of the Freight Marketing Circular does not apply to cases where approvals have been granted and the applicant for railway siding has acted on the basis of such approvals and work for setting up of the private siding has progressed. In this case, admittedly, the project of setting up of the railway siding at Jaroli was approved on 3rd March 2006. Detailed project report was approved on 6th February 2007. Engineering plan was approved on 17th May 2007 and the land licensing plan was approved on 17th March 2008. All these approvals were given long before issuance of the Freight Marketing Circular number 12 of 2008, which is dated 28th of August 2008. After getting the approval in principle, the petitioner under the covering letter of 17th March 2008 submitted demand draft amounting to so-and-so to the railways on account of land licensing fees and towards such and such, toward codal charges, etc. This payment was made on the direction of the railways on 18th May. These are all the charges that has been paid. Kindly need not be troubled with that. Now, on the main part, please take page. But the yes. The mark is. Page 48. Missing actually. But I think some pages are missing. May I come back on the next day with a complete set? I think some pages are missing.
Missing?
Yes. Though it's in chronology, but I think some pages are missing.
So এটাকে তাহলে ইয়ে করে রাখুন।
Yes. না, এই তো ওর সাথে
ওই হার্ড ইন পার্ট।
Yes, yes.
Fifth September.
No, sure.
5th September.
Yes,
at 2 p.m.
But kindly take the supplementary affidavit on record.
Yes. Supplementary affidavit filed on behalf of the petitioners be taken on record.
Supplement দেয়া আছে তবু একটা দিয়ে দেবো। এই একটা সাপ্লিমেন্টারি এফিডেভিট আমাকে দিয়ে দাও। সে দিয়ে দিচ্ছি। আরেকবার দিয়ে দাও না, মিসপ্লেস হয়েছে। দিলেও আরেকবার দিয়ে দাও।
argument is heard in part, fixed 5th September.
But what I believe has happened is two judgments, Milord, in the while photocopying, Milord, they have got merged.
It is you have
There are two
taken it now.
judgments.
You have taken it from the server.
No, we have certified copies, but somehow
acha, acha.
there's something wrong. And Milord,
So kindly check it up with the server.
Yes,
because old matters have been already. It has been.
and Milord, there's an appeal
uploaded.
preferred by the railways against this, but this has never come up for consideration.
Okay. Okay.
Check one, check.
Criminal.
I'm grateful, Milord. Supplement. I'm grateful, Milord.
Who will submit?
Milord, may I only make one request, Milord? Instead of 5th, could it be, Milord, the next week or 4th, whichever?
No, 4th it is not possible. I have already fixed lots of cases. I do not know.
11th in that case, because I intend to bunk court on 8th.
Why will
7, 8, 9, 10.
Oh, I thought that you will go to BRICS conference.
So,
on 8th, Supreme Court has declared holiday.
Oh, declared holiday?
Yes, because of G20
meeting over there.
Yes, G20 meeting. So I thought that you will be there.
No, that's not my cup of tea.
Maybe I do. We do not know. So
you know that I have an avenue open over there, but I don't pursue that.
Yes, that I know.
No,
Then
11th.
I'm fixing it on 11th. I do not know also what will be my fate.
There's some uncertainty, I also.
Yes. Practically, I'm running with uncertainty because I'm hearing the matter. It is very difficult to sit idle.
Yes.
For such long days, and I'm hearing the matters. The matters regularly now I am disposing of.
Yes, that's better.
In this way, I'm continuing. So on 11th, let it be there.
11th. I'm grateful.
Yes, CRA, other matters are released.
Next matter, my lord, after Mr. Datta's matter, my lord, is the case of state syndicate bank versus my lord syndicate bank. My lord, meanwhile, my lord merged with the Canada Bank. My lord, I have filed one application, copy served to the respective party. My learned friend is on behalf of the KMDA. My lord, let my lord this change of devolution of interest, my lord, may be recorded, my lord, and the next date, any date, my lord, the matter will be taken up for hearing.
Hey, next matter na to be mentioned এ কালকে নিয়ে আসুন আমি সকালবেলায় অর্ডার করে দেব.
Deeply obliged, deeply obliged.
Yes, this is a small matter to be mentioned. The application will be disposed of.
After recording that change.
After recording,
any
yes,
date.
yes. Thereafter that date will be fixed.
KMC is also party.
Yes.
We have prepared written some strategies.
কপি দিয়েছে তো
না ওদের কপি ডাউন
কপি দিয়েছিস না আমাদের my written notes, my lord. I didn't want to trouble your lordship with oral arguments. I've put everything in one place.
Yeah, it has been substantially heard.
The judgments are there.
All the judgments are there in my compilation. In my written notes,
We have given separate compilation for judgment and the written notes.
just to indicate to your lordship, my lord, how I have given my judgments, my lord. If your lordship just takes, my lord, page 13 of my written notes, my lord. Page 13, my lord.
Yes.
There your lordship will find I have named the judgment, and then, my lord, I have within brackets written see page 30 to 39 of written notes.
Yes.
So, my lord, this judgment your lordship will find in page 30 of this document itself.
Yes.
Likewise, my lord, the other judgments wherever it is referred to,
Yes.
I have given the page number. and everything is in one place, my lord.
Yes.
So that
yes,
your
yes,
lordship
yes.
doesn't
Be-
need to look
uh,
here and there.
No, it will be more helpful for me.
Lordship. At least I tried, my lord, not to trouble your lordship too much with several other documents, my lord. I tried to put it in one place.
Yes.
কপিটা নিয়ে না
So,
এই বীরবলকে কপি
so let
এইটা
Mr. Chaudhuri, let me read out these two things
yes
on Saturday and start dictating the judgment on from Sunday.
yes.
If it is possible, Sunday, Monday, Tuesday, I hope that I will deliver the judgment.
My lord, we also hope. We also hope. Because lordship has kept Mr. Dotto's matter on 11th, if I'm not wrong.
What can be done? I do not know whether on by 11th and also if the order comes or the warrant comes, in that event also I require at least 10 to 15 days time.
Correct, my lord. Absolutely.
Because it is all these things I am learning that it is generally in case of practically there is no transfer order for the High Court judges.
Yes.
It is appointment.
Correct.
The appointment order is from the date he
assumes
assumes
office.
charge
Assumes
of
office.
charge of his office. So from the date means that
the oath,
the date of oath.
date of oath. So that liberty should be given to me. Some date, because I am hearing the matters.
Absolutely. And my lord, it doesn't also affect matters in which judgments have been reserved, because those are
yes.
those
In
are
fact,
already reserved.
my lord, last week, subject to correction, my lord, I was going through live law. There was one judgment which says that judgments which have been made CAV. Even after transfer, my lord, the judgment can be delivered.
Yes, my lord, that is
Because the hearing is complete.
that is no longer res integra. That is absolutely settled.
Judgment can be.
Subject to correction. I was just seeing in live law.
You are right. Judgment can be.
Yes, judgment can be delivered.
That is the thing. But if these things goes on,
what can I say, my lord?
No,
my heart
please,
is very
no,
heavy.
no. Please,
My heart is very heavy.
please consider when your turn will come. Both of your turn will come, I hope. But when your turn will come, please consider this.
This was
If you are-
absolutely shocking to all of us.
If you are no, not
Shocking.
that, not that. Practically, the learned advocates coming from the bar and the officers coming from the service, there is some